I don't ever slow up, no I don't take shit. I got no love for the fakeness. If you wanna play tough and wanna hate this, I'll always show up. I don't ever slow up, no I don't take shit. I got no love for the fakeness. If you wanna play tough and wanna hate this, I'll always show up and make a statement. I don't ever slow up, no I don't take shit. I got no love for the fakeness. If you wanna play tough and wanna hate this, I'll always show up and make a statement. Everything I do so instinctive.
Good evening, ladies and gentlemen, degenerate sleuths of the night. We gather to boldly go where others have refused. Welcome to the DT show, you salty mofos.
A man accused of killing 4 college students is behind bars, and he has ties to northeastern and central Pennsylvania. State police say 28-year-old Bryan Kohberger was arrested this morning at a home in Chestnut Hill Township.
I can't find any case law that would support that idea. That somehow a warrant would be needed for DNA left at a crime scene.
We are expecting to learn more about the allegations against the girlfriend of a Boston police officer who was found unresponsive in the snow Saturday morning. I-Team sources say Karen Reed was in a relationship with John O'Keefe. She's facing charges including motor vehicle homicide and manslaughter.
So, the Commonwealth just provided the court with information that causes me grave concern. The implications of that information may have profound effects on this defense and defense counsel.
So, get your popcorn ready and your choice of drink. Get your butt on your seat. Like, comment, and subscribe for a treat. Here we go. It's time for the show. The Drunk Turkey Show.
Apparently, I'm still muted. I apologize, guys. Thank God I was looking at the direction of the chat this time and not just talking. Well, welcome, guys. Welcome to the show. Today, there's a pretrial hearing going on, and there's a lot of things that are going to be going through today. In fact, it may actually go into tomorrow. I'm not entirely sure, but I know that one of the biggest things that's being expressed or talked about today as far as interest goes into this case is going to be the defense's alternate suspects theory, who they think may have committed this crime outside of Bryan Kohberger. Let's look at a couple of things before we start the show. At least you know how to mute. Yeah, I do know how to mute. All right, so let's look at the case summary. Let's see. The hearing is scheduled for pretrial conference 9 a.m. and this is Boise time, so it should be coming on in the next 22 minutes. I'm already here waiting. It's still offline, obviously. Wait, maybe not anymore. They didn't do that earlier, but we'll see. I have the audio up. Yes, there it is. This is true. Hippler insinuated the name must be given for it to be admissible, so we're going to figure out who it is and some other things as well. So you have the hearing. We have a couple of things that are in the case summary that are not yet a part of the actual documents that have been released, probably because of this hearing hasn't been put out there yet. So you have, we'll go back to the 13th, an order sealing the parties' joint proposed jury instructions. We've seen that. The 13th, also motion to redact or seal newly filed records. This is motion to seal Exhibit S1 of the state's motion to reclaim exhibits. State's motion to reclaim exhibits and notice of compliance on the 14th. Now, this notice of compliance, is that the compliance for this trial that's coming up today? I don't know. As far as I know, let me go back here. I don't see anything here as far as order of compliance. So could it be, this is sealed, right? Now, the hearing today ain't sealed, but what is sealed? We know that the examination with Bryan Kohberger with the doctors, that's sealed, and the information that's coming out of that is sealed. So could that be what they're referencing when it's when they're talking about the order of compliance? Because obviously it's not here yet. Now the courts have been known to do some things where they hold on to some documents for a little while that they have no intention on sealing, and it just comes out a little bit later. Maybe they're waiting for some other documents before they make it public, or a hearing, like in this case, perhaps before they make it public. Maybe they don't want everybody to go through these alternate suspects or suspect theory that they have and debunk it before this hearing even starts. I don't know. But maybe we'll find out today. Hopefully, and maybe it'll come out after this trial. Yes, please hit the like button, subscribe, ring the notification bell. You guys know what to do. I do have a poll going on in the live chat asking, did Bryan Kohberger do it? Now, I'm not asking if he is guilty or not guilty. None of those things, because we haven't seen all the evidence. We haven't gone through trial. We haven't done anything. We haven't even done jury selection in this case. So based on the evidence that is out there, do you think he did it, or do you think he didn't do it? And there's an option there if you truly, honestly do not know or have an opinion one way or another. All right, so let's I'm gonna roll back here. Yeah, it still says offline. So we have about 19 minutes. And with that 19 minutes, I want to address something. So we went onto a video yesterday. Part of my live yesterday was about Datelines. In the Dateline series, there was a search that was made for Ted Bundy on August 16th. And then a short time after that, Dateline says that there's a picture posted on social media, and then there's a 911 call for a loud noise complaint. And so I was asking the question, like, what is it that Dateline is trying to say here? You know, what is Dateline saying? Is Dateline saying that Bryan Kohberger made that 911 call? Now, let me pull this up. This is the Moscow Police Department daily activity log for Tuesday, August 16th, 2022. Now, before I go into it, I do want to say, like I mentioned in yesterday's live, that sometimes when you have sources or sometimes when you have information that you're trying to put out there, you can't put it out there direct and say, hey, this is it. You got to kind of put out some breadcrumbs and let people, connect those dots. And sometimes, and that's what I was referring to when it came to like Howard Bloom and some of the things that maybe he didn't get completely accurate. I don't know what Dateline's trying to say, if they were trying to say that Bryan Kohberger made that 911 call, or if that Bryan Kohberger was searching online and that he was online at the time. He was watching videos of Ted Bundy, so he was actively on his phone, online, or on his computer. And then that this picture posted up, of the girls outside. And now there's a 911, call. Maybe perhaps that 911 call is just going to capture him there in the background, like I pointed out. But it was the actual the picture that was posted online that sparked Bryan Kohberger's interest, that maybe perhaps he went out there. I don't know if he did or not, but I don't, I'm kind of cautious now as to what Dateline was trying to allude there. Because to me, it seemed like they say, all right, at this time on August 16th, he was searching Ted Bundy. And then right after that, there's this picture that's posted, and then there's a 911 call. I mean, yes, those are the things that happen in that order. Could it all be coincidence? Perhaps it could be. But let's break this down. So this is the August 16th, 2022 daily activity log. And if I scroll down, it says here for noise complaint, 1100 block King Road. And it says reporter reporting that loud music, people standing on the roof drinking, unknown how long it's been up there for or going on. The reportee is just got home recently. Reportee can hear inside her home. Officers responded, subject warned, no report. Now she's saying that, it says here her home. I'm going to take its word and say that, yeah, it's most likely a female who made this noise complaint. I'm not afraid of the truth, guys. I strongly suspect that Bryan Kohberger committed this crime. I don't need to glorify anything that's not true. And so I'll report it if I find out. And if you guys have anything that objects to what I've put out there, please send it to me. I want to make sure that the narrative is correct and right. And so it says here her home. It could be a mistake, but I'm going to take it for its value that it's correct and that this was a female that actually that made this phone call. All right, so obviously it wasn't Bryan Kohberger if it was a female. And then slightly below that at 1734, at 534, officer required a case. This is the other loud noise complaint because as you can see, they're walking and they hear it. And so this is an officer reported. This isn't another 911 call. This isn't somebody else calling 911. Now, does that mean that Bryan Kohberger wasn't out there? I don't know. Could he have been out there? Maybe. Now, Dayline is alluding to something. They're alluding that he was online and then that picture was posted up. Perhaps maybe what they're alluding to is the fact that he went out there because of the post online, indicating that he was surveilling them through, some form or fashion, and then maybe went out there and got caught on camera. I don't know. Or maybe, there's the possibility that car that's on camera is 100% an Elantra and could be an Elantra that's not related to Bryan Kohberger. Now, I know the Probergers are going to jump all over that and say, you see, look, there's an Elantra there and it's not Bryan Kohberger's. But there's a little bit more to it, right? Did that Elantra, was that one out and about, in the early morning hours of November 13th? Was that Elantra, the owner of that Elantra, do they not have an alibi? Because if it was just strictly that Bryan Kohberger drove a white Elantra, he would not be in custody. That's not the only thing that has him in custody. It's the fact that his DNA is also at the scene on a weapon or on an item that held the weapon, an item that the murderer brought into the house. It's single sourced and it's a significant amount of DNA cells, meaning direct contact. There was a lot of people in that house the night before. So a lot of the DNA there that was in the house can be attributed to a lot of the people that were there, except for the thing that was brought in by the killer. You also have the fact that his phone was off during the time of the murders and the fact that he has admitted to being by himself out and about in his vehicle without a front license plate during those specific hours of the crime. Nobody else was with him. He didn't lend out his car. He didn't do any of those things. He was by himself with his phone off. We have purchase history of a weapon matching the description of the weapon that was potentially used, and also the knife sheath. Now, the reason why I say potentially is because they didn't recover, or at least to my knowledge, have not recovered the knife. So is it possible that in order and efforts to throw off, law enforcement, he used a different knife? Perhaps, but I doubt it. I mean, it's missing, right? So, but because they haven't located it, I guess you can say there's a slight 0.00001% chance it could have been a different knife. But either way, there's the knife and the knife sheath K-bar knife. There's purchase history of that. There's a witness that saw a man wearing a weird mask. She couldn't describe it. She didn't know what a balaclava mask was when she was asked a question about it. She had to be seen a picture of it. But early on, she described it being a weird mask. Even in her text messages to Bethany, it was a weird mask. Not something that she was used to seeing. And Bryan Kohberger had purchased a mask very similar to that prior to his move. So it's more than just the white Elantra. Obviously, white cars are pretty normal in that area and stuff like that. But Dayline is putting these things in order for a reason. And I can't think that it's not a reason that maybe perhaps we're just not connecting the dots right. I had a couple of people reach out to me and send me a couple of photos as well. Let me pull this up real quick. And this photo and this photo were sent to me saying, hey, maybe these are the white cars that you see back there. And the problem is, well, first and foremost, this thing has a little bit of a black thing at the bottom of the bumper. This one doesn't. So that's a negator. This one, maybe. I mean, this one has the elongated taillights. Let me pull that back up real quick. This one is a maybe. Elongated taillights. Reflectors are a little bit weird, though. Look, these reflectors are way out here, way out to the edge. See, this is the curvature, and it's like almost part of the curve are the reflectors. These reflectors are inward, like almost kind of closer to the under part of this taillight. And here's that black part of the portion of the bumper. This looks like it could potentially have a black portion of the bumper, but as you can see, it's pretty long. But I honestly can't tell if it's there or not. But if there is one, it's a longer one than the one that I'm seeing in this reflection. You know, to me, when you pull up this image here, that looks a little bit, I mean, it's a thicker black area as well. You have your reflectors, long tail lights. So, I mean, it very well could be. This one could be it. You know, this one looks like a Honda Accord or something like that. But the other thing too is right here. This is straight edged. You can, I mean, I know it's hard to tell. It's hard to tell here, but this the bottom part of the window frame, since it's covered in snow, it's straight and then it curves up like that. I know it might be hard to see, but let's pull up the video here, and this will be the stabilized portion of the video that we were looking at yesterday. It goes up. It's not straight. It goes up. It curves up. So I don't know. Maybe it is the same car as the one that's covered in a lot of snow. Maybe it's not. You guys tell me. I think this one definitely could be an Elantra. It could not be an Elantra. It could be an Elantra and not Bryan Kohberger's Elantra. There's a lot of possibilities here, right? But you guys tell me. You guys tell me. All right, let me remove this real quick. Okay. Give me a second. All right. So, I don't know. But I wanted to bring that up to y'all's attention and let you guys know those are there. But I did go through. So here's the other thing too about the this website here, right? There's a lot of dates missing. A lot of dates missing from this website as far as things that we know of that occurred. So this one has the noise complaint. We'll go through them. I went and looked everything up between the time that Bryan Kohberger moved to the area. Was it like June 25th, 2022 to November 13th, 2022, the night of the murders. And I looked up a bunch of the history in the area, the calls in the area. So the first one's out of order. I wanted to go to the first one just so we can address that video that we just spoke about. There was 2 noise complaints there. And then I believe there was another one later on that night. It says King Road near Taylor. Disposition was a warning. This was at 10 o'clock. This is at 10:11 p.m. So this is after, around the time when the document says that Bryan Kohberger was in the, could have been in the area. A lot of the times that it mentions was between 10 and 4 p.m. Now, the reason why I think they mentioned 10 and 4 p.m. and they're really harping on that is because Bryan Kohberger, from what I understand, said something to the effect that he likes to go shopping in Idaho and things like that. So they really focused on the times where he's not really shopping, right? You can't be shopping between 10 and 4 p.m., 10 p.m. and 4 a.m. In the morning in Moscow. Everything closes down out there. So then you minimize that down to 100 meters from the victim's residence. So he was out there, guys. He was out there. All right. So noise complaint at 10:11, reporting 2 houses. Reporter is reporting that there was 2 house parties, ongoing issues. Officers responded, no report. So there was actually another call out there later on in the evening. Now, I couldn't find the September 2nd complaint when they went back out there and they talked to Xana. And that's one of the ones that's not in here. That's the reason why I'm saying, like, not everything is in here. There's one earlier in that day. Remember when nobody's at home and they call Maddie on the phone? That one's in here, but not the September 2nd one. It's weird. It's weird. I don't know why. All right, so let's go in order. The next one is, and I should have had this one way up here, July 17th. What did I highlight? There was a burglary, 500 block of Queen Road. Reporter believes someone might have tried to break into their apartment. Officers responded, report taken. So this is around the time when Bryan Kohberger's in that area for the first couple of times. Remember, I think the Grove party was like July 9th. I want to say it was. Maybe it was June 9th. But they mentioned that he was in the area between July, I think it was July 9th, between July 9th and, yeah, it was July 9th. I apologize. It was not June. He wasn't there until late June. So between July 9th and mid-August, he was there 12 times, all in the early morning hours, late evening hours. And so could he have been like trolling the area in early July? All right. Yeah, July 17th. I wanted to make sure. Could he have been trolling the area in early July, maybe looking for people in that area? I don't know. Again, none of these say, I'm not indicating that any of these are Bryan Kohberger that I'm going to be pulling out. I don't know. I'm just looking up some interesting things that are, maybe should be looked at closely. I'm sure law enforcement did. Let's put it that way as well. I'm not saying law enforcement didn't. And I don't know if we'll ever hear about these in this case, unless he did actually break into a house and they're going to try to show a pattern in it and an escalation of breaking in. And then, we do know that he broke into, or allegedly possibly broke into, his female friend's PhD student friend, Nayoung Ko apartment and moved some things around, or she believes that it was him that moved some things around and did some things. And the reason she believes it was him was because her key for her apartment that was in her office that she shared with Bryan Kohberger went missing. And then it rematerialized a few days later. She asked him about it. And when she asked him about it, it rematerialized a couple hours after that. So it's pretty obvious what happened and what it was. So escalation, step up, boom, boom, boom. Did he try to break into another house in that area before? I don't know. It's September 1st, 2022. Now, this is the one where it has the loud noise complaint. Here it is. Noise complaint here, 1100 Queen Road. Remember that where they lived and where they were. It says here, this one was reported at 10:34. A reporter reporting loud music and drinking outside. Officers responded, no report. This one, I don't know who called it in. I'm sure if it's in here, it's probably not Bryan Kohberger. But September 2nd, the one that happens at 12:36 a.m., where Xana comes out and she's like, I'm here, blah, blah, blah. And, I'll tell everybody to go inside. And the officer's talking to her. That one's nowhere to be found. September 4th, noise complaint. Now, this could be anybody. A reporter complaining about a vehicle parking lot that has been blaring music for the last 20 minutes. It was in the area, so I just highlighted it because it came up so that I can explain to you guys. This was in the 500 block of Queen Road. Somebody just jamming out in their car. That obviously could be anybody. Let's see if this is on yet. Not yet. All right, September 16th. Let's see what I highlighted here. Electrical hazard. So obviously nothing to do with anything nefarious. King and Queen Road intersection. Low wire hanging. Now this one was weird. This one is weird. This is a suspicious person / circumstances. This is on White Avenue near the roundabout. It says one male standing on one side of the road wearing a black knit cap over their face and head. Officers responded, no report. Now, the reason why I think this is interesting is because White Avenue happens to be the road where the White Elantra was coming from. Remember where there was the gas station on that came out like at 3:45 or 3:40 in the morning or whatever. Now, I know a lot of people are going to look at that and say, "Oh, that time don't match up with what the other times that are, in the documents as far as they have the white Elantra in the neighborhood that is literally 2 blocks away. It's 2 blocks away. It's not like it's on the other side of the town, the other side of town. It's 2 blocks away. So we looked at throughout those documents that showed a listed times documented when they saw the white Elantra, and I found it odd that every gas station that they had, the time was off. The houses were on point. First, obviously they were more, I think, approximately, but they said that they were on point. Like the document specified that these cameras, the one on Ridge Road, Linda Lane, all these other ones were accurate. The gas station videos were all inaccurate, some by a couple minutes, some by longer. And so I don't know exactly, since it was a gas station image or video that came out, is how off is that video? Is it a couple minutes? Is it a minute? Is it 5? And that really could make a difference, because again, Bryan Kohberger's car allegedly passed by there, and where the vehicle was on camera, like on Ridge Road, it's like 2-3 blocks away. It's not very far. And so I think that would make a big difference. And this scenario here with this guy wearing a white mask covering his, face and head, could be him, could be somebody else. I mean, it could be a prank for all we know. You know what I'm saying? So not everything that I'm pointing out is that. I'm just pointing it out. Let's see. All right, let me see if this is on yet. Hopefully it is. And let me know in the comment section, guys, if you guys see something that is going on. And refresh your page. There are new documents. All right, let me see what's up. Holy smokes, there are new documents. Thank you, Amber. Whose name is going to be dropped as a suspect? I have no idea. No idea. Thank you, 49er girl. And Miss Emmy became a YouTube member. Thank you. Thank you for letting me know about that. Let's see. Order sealing the statement, order sealing exhibit, order permitting state to reclaim exhibits, jury instructions, governing courtroom conduct. I don't see anything about the defense, and I don't see anything about the defense documents for alternate suspects. Do you see that, guys? I don't see it. I don't see it at all. Let's see. All right. This thing should be starting any moment now. If anybody sees it coming up somewhere else, let me know. Like if somebody has it somewhere else. Have I come across a report of a man driving around campus for an hour? No, I have not, but I have not gone through everything there. I did a specific search given the amount of time that I had before today's show. I did a specific search for King Road, Queen Road, and in that area. And so I didn't look for anything around campus. There very well could be. I just didn't have any time. I was just very specific between the date range and stuff like that. If I put everything in between there, I'd be there all day. If not longer, multiple days. Let's see. It should be starting. Let me know, guys, if you guys see it somewhere. You know, these things never start on time. Let me pull this out real quick and see if I can find it, like if it's on something else. I'm gonna see if it's like on Law and Crime or something real quick. It should be on this 4th district thing, but it's still offline. Just want to see if there's anything else somewhere else. All right. So it's starting soon. I'm gonna mute it here. All right. So it'll be starting soon. So it is gonna go down. It's going down. We're gonna listen to it here until it starts, and maybe I'll swap it back over to the other deal. Yeah, I keep refreshing too. So I'm gonna see, like, these guys will definitely be on point with it. They'll start it once it starts, and I'll jump back on there, depending on the audio. You know, if the audio is good in one spot, it may not be good in another. You know what I mean? But I'm not expecting to hear much. You know, real quick, I guess while we have that, don't want to unmute it because I don't want to get into a big old. You know, I'm gonna unmute it. I'm just gonna turn it down. There you go. I'm going to keep it like that just in case it starts. I can hear it. You know what I'm saying? So that way we're not late. All right. Yeah, I can hear it. Okay. So ordering schedule notice states amended exhibit list. Let's go through some of these real quick. Let me close this down real quick while we're waiting. All right. Order sealing notice amended exhibit list. Based on the state's notice of amended exhibit list, a motion to seal filed here in the court does hereby confirm order the state's notice to amend exhibit list is exempt from disclosure and is sealed. So none crazy, obviously. Sealed reclaim. Let's see how many. 2 pages. Same thing. They're going to seal it. I mean, you can tell from, what are they sealing? Exhibit S1. What's Exhibit S1? You know, they had that unsealed a while ago. We went through it. I wish I could remember. It's just so much of this stuff. I couldn't remember what S1 was specifically. But I wonder which one it was. All right. Order permitting state to reclaim its exhibits. Let's see if there's anything here. Order permitting the state to reclaim its exhibits. And it's just the order saying that. Second order sealing defendant's proposed jury instruction. And the motion to seal, let's see if there's anything more than 2 pages here. Nope. And nope. Amended order. Oh, so we went through that. And we went through these already too. The state's motion to reclaim exhibits. Yeah. Come now, State Idaho through court proceeding. Attorney moves the court pursuant for an order permitting the state to reclaim the exhibits the attached state's exhibit S1 offered and admitted at grand jury proceeding hearing. The state prepared to substitute copy, photograph, draw, facsimile, or other reproduction of the exhibits is requested by the court. Hey, Forensic Frenzy, how's it going? Good to see you. Good to see you. Maybe Kohberger escaped. That'd be crazy, right? Jumped out of a window on the second floor or something like that. Something weird. For those that don't know what I'm talking about, that's a Ted Bundy reference. And I'm not gonna. So throughout the entire hearing, for the most part, I think, unless something pops up and I got to jump up real quick and do something, I plan to just be sitting in here and watching and maybe throwing in a little comments here and there. I don't plan on interrupting too much, but I'll be honest, I'm a very reactionary person, so you might hear a "come on, man" or something like that throughout the entire thing, but I'll try to keep it down to a limit. How's it going, Nikki? Nikki says, "Thank you, Daniel, for all you do. Glad to be here on the live stream with you today." I'm glad you guys are here. Thank you, guys. Thank you, everybody that's here today. I appreciate you guys. Please like and subscribe while you're here. Hit that notification button. You guys know what to do. And, I know some folks are complaining about some ads and stuff. Let me see if I can turn that down a little bit. That's not what this is about. There it is. There we go. Turn that all the way down. Thank you, guys. Thank you, Amber. I appreciate that. Thank you. Thank you, Tyler. I'm supposed to be painting a ceiling right now, but you must follow your heart. YouTube Premium is totally worth it. You're never getting. I have the YouTube Premium too. I won't deny I like it. I like it a lot. I get a lot. So I know I went through this one. This is the amended order governing courtroom conduct. So all this stuff here means, guys, the reclaiming of exhibits, all this, the courtroom conduct means we're going to trial. We're getting ready. It's happening. It's not going to be pushed back. There's not going to be a continuance. As much as Bryan Kohberger and Ann Taylor may whine and cry about it, that they don't want to go. There's too much evidence against him to go through it. She's taking up another death penalty case, but it's still too much evidence. And she's using some of the same tactics. I heard, I don't know this for sure. I'll be honest. I don't know this for sure. Somebody sent me something and I read something saying that that with the Skylar Meade case, they did they remained silent. And when the plea came in, they didn't do a plea of guilt or innocence. And so, a lot of people were pointing out that maybe perhaps Bryan Kohberger had a lot to do with how Ann Taylor is trying her case. And maybe that's the case. And maybe perhaps she's taking pointers from him. But what I think is more than likely probably true is that this is just the way she does things. You know what I'm saying? She refuses to delegate. Well, I mean, yeah, I agree, Afton. She does refuse to delegate, but I don't think that. I think she's magnifying the uselessness evidence and material that's put in there, right? She said that they said they wanted everything because they wanted to find, something. They were trying to find some sort of loophole, some sort of other vehicle out there, something that they can kind of magnify into pointing in a different direction. So when they asked for everything, they got everything. Now, should she delegate those to other people? Yeah, 100%. But I don't know. Maybe she's afraid that people are going to start talking like, hey, there's nothing here. You know what I'm saying? I don't know. But to me, I think it's more of she knows that most of it is useless, but she's gonna magnify it. That's her job. Her job is trying to defend her client. That's the one thing that I think I'd have a hard time doing, guys. Like I get it. It's a job and somebody has to do it. But me personally, I don't know how I could defend a Bryan Kohberger like this in the same manner, especially if there are some things that are obvious, and there are some things that she probably knows. Like, first and foremost, let's talk about the alibi. So the alibi situation is there was a hearing where the defense was asking for things, and I'm pretty sure it was a call detail records, the call timing advance records for Bryan Kohberger, because she was asking for things, and Bill Thompson's like, we don't have them. And that's the one thing that they don't have. And he kept saying, it's like, how can we give you something we don't have? And she's like, you know, they have it. We know they have it. They reference it about other things and other documents. So we know they have it, meaning that they reference other persons, the other 1,300 or whatever, 3,800 people that they got a phone dump from, all these other things. They completely blew past the 7-day timing. But this is all that was, right? And so during that trial, or during that pre-trial hearing, the alibi came up, and Ann Taylor used some words basically that Bill Thompson used, said, you know, I've given you all that I have. I don't have any more. If I had more, we would give you more. And when things come in, we'll give you those things. So she was basically mocking him, saying the same thing over. Oh, okay. Oh, you know what that means? Yep. All right, let me close this off real quick. You know, yeah, let me close this. Just gonna pause it in case I got to come back to it. Full blast. All right, so it should be starting soon. All right, so she comes back and she says something to the effect like, all right, hey, you know, I don't have it. When we get more, I'll let you know. And at the time, what they knew was that Bryan Kohberger was driving around early morning hours, and he doesn't have a specific time or a specific place he was at any time or place that night. And this is before he even mentioned the Worldwide Park. This is before he mentioned any of those things. And so, needless to say, what she is saying is Bryan Kohberger is, even he has told her or has not told her where he was during that specific hours. She didn't know at that time. And based on what we've seen in court documents, she still don't know. Now, do you think that's because Bryan Kohberger refuses to tell her? Or do you think that's because maybe she's like, hey, you know, if I'm going to represent you, I might need to know some things. And maybe there's some things that's better I don't know. Is this something I need to know? All right. And if it didn't go down that way, don't you think she'd be a little bit suspicious as to why he himself hasn't told her exactly where he was at 4 o'clock or during the time of the murders? So take that for what it is. You know, I think it's pretty obvious. Mountain Guy says, I think Kohberger is running the show and is his puppet. Thank you, Angela, for being the newest member. And we have Nikki coming in with her membership for 1 month. Thank you, Daniel, for all you do. Glad to be here on the live stream with you today. Thank you. I appreciate that. And then we have Pancakes coming in with a $5 super sticker. Thank you so much. Thank you. Let me check something real quick. I'm going to check the poll. Where are we at right now? And I wonder if it'll change after the fact, after this hearing gets on its way. We are at 86% and quite a bit. Let me see. Let me go back. All right. So did BK do it? 86% say yes at this point. 698 votes. Pretty good amount of votes. 86% say yes. 5% saying no. 10% saying I don't know. So about 70 of you guys saying you don't know, and about 35 of you guys saying he didn't do it. And the rest of this 700, about just shy of 600 or just shy of 600 people say that they believe that he did do it. Bundy Burger is funny. I call him wannabe Bundy. That's true. That is true, Forensic. That's true. I do think he is a wannabe Bundy. I'm asked if I would do something that there's no way he did this alone. I don't think. Or those girls knew something and they ain't speaking up for the roommates. Well, here's the thing, right? Let's break down this thing about the roommates. So they have a download of their phones, download of everybody's phones, including the victims and the roommates, and a lot of the individuals who they were investigating. They turned over their stuff. The Sigma Chi guys, everybody, they turned in their DNA, whole 9 yards. Now, obviously, we're not going to hear about that because they were cleared, and there's no point. This isn't a crime. This isn't the trial of them. This is the trial of Bryan Kohberger. So we're not going to hear about the people that got cleared and why they got cleared and how they got cleared. Now, as far as did he do it alone, well, back to the roommates. They have a download of their phone. And so why, I don't understand how they would go through their phones, figure out they had something to do with it, and not act upon it. Like, why not do that? Now, I know some people might say, well, it's because they're females. If they were men, they'd be in jail. Well, Emma Bailey is a female, and she went to jail for the accidental overdose and maybe not accidental, the bad batch given to Caden Young, which caused an overdose. Now, they arrested her and they arrested D. Robinson. So they had no problems arresting a female for a murder of somebody, and one that was much less of a heinous type of crime, I want to say. I mean, yes, somebody lost their life and it's a horrible situation and somebody needs to, go to jail for it, et cetera, et cetera. But, the heinousness behind the crime itself, between what happened on 1122 King Road and what happened with Caden Young is there's no comparison. And so why wouldn't they arrest these people? Why wouldn't they go after them if they found anything there? And especially if it tied it back to Bryan Kohberger. Now, even the defense says there's nothing that ties them together. There's nothing that connects them, meaning there probably isn't anything like Bryan Kohberger following them and them following him back. That would be a connection. Just kind of like when Dr. Ramsland brought up that there was no email correspondence and that Bryan Kohberger hadn't contacted her since his arrest. Which was interesting because, if there was no email correspondence while he was at WSU, why not just say that she had not been in contact with Bryan Kohberger, or he hadn't contacted before he moved out to Pullman, or before he, was in WSU? You can knock out both of those things at one time. By saying no email correspondence, that means that she did not respond to any unprovoked emails, meaning that Bryan Kohberger, what it sounds like to me is that Bryan Kohberger emailed her out of the blue, and she didn't respond for whatever reason, whether it be she ignored him, whether it be she had too many things and she didn't see it, or whatever the case may have been. And so it just sounds like at some point before his arrest that he did reach out to her. I wonder what that was about. But could he have done it alone? Now, I think that there's plenty of time to do it alone. There was a reenactment done by law enforcement, and they were able to reenact it at between 2 to 4 minutes. Now, he's pulling back there around 4:07. He's leaving the house around 4:19. Granted, I get it. The car is seen leaving at a high rate of speed at 4:20 and like 40 some odd, seconds. And I think 48 seconds is when he's seen leaving at a rapid high rate of speed. But there was a time there where he's undressing and getting into other clothing, in my opinion. And so, and we know that because Dylan made a phone call to Bethany talking about what she saw, and that call started at 4:19. So obviously that call came after she saw him leave. So whether it be 20 seconds, 30 seconds, or a minute after she saw him, it's probably around that 4:18 mark when allegedly Bryan Kohberger walked out of that house. It gives you about 2 minutes, almost 3 minutes to change and get into your car. And if he's wearing just a jumpsuit and things like that, and he has something prepared there, it's not going to take very long. And so I think he had plenty of time to do what he did. There was a guy in Australia, I think it was a shopping center, who lost it. And he ended up stabbing like 16 people or 18 people, taking the life of 6. And he did this in about like 11 minutes. And this was on 3 floors of a shopping center. And a large amount of that time was him running away from law enforcement. And so those things, it's fairly quick. In that scenario, none of that guy's victims were asleep, drunk, and intoxicated in the wee early morning hours. They were all aware and awake. So, yeah. Could he have had somebody else do it with him? I don't know. I don't think so. I think that would be kind of hard. I mean, they got Bryan Kohberger's phone now. They've downloaded his phone. If he had an accomplice, they went back pretty far back. I'm sure they investigated everybody that he's met, talked to, seen, anybody who was ever on his phone at one point. They're probably investigated all those people to see if he did have an accomplice, if he could have been, with somebody. He wasn't there very long either, guys. So it's not like it would be a long list of people they'd have to investigate. He seemed like a loner, quiet guy, those type of things. And we've been on an hour and this thing hasn't even started yet. What's going on? Does this usually take this long? Let me double check the here. All right, yeah. No. What are you doing? Oh yeah, no, it's still not on. Still not on. All right. Steph C says no evidence to support a second perp. I don't think so either. The evidence that the defense is going to say, so let me do my little psychic thing, right? The evidence that the defense is going to say is the fact that it appears that there's two weapons that were being used, that the damages or the injuries to Kaylee's body were consistent with more than just a stabbing. But one item can be used in more than one way. You can stab somebody with the sharp end of the knife and use the bottom end of the knife, the butt end of the knife, as a blunt force object. And thus you have two different patterns of injuries, etc. We'll see. We'll find out today. I hope it's not like too graphic, because I think Steve and his family are going to be in there. And I don't know how graphic they're going to get into to try to explain why there could be more than one person that was involved in this, but we'll see. Let's see. Natalie James comes in with a $9.99 off topic, but are you going to deep dive on Gilgo Herman? I would much rather watch you cover it than other channels. We may have slow period on Idaho after today. I've actually talked a little bit about Gilgo. I'm not as well informed on that case, to be 110% honest with you. I'd have to start from the beginning, because I don't know everything from it or anything about it. I know that there was a lot of people that went missing for a long time. I actually had a friend at one point that was in the military that was going to get stationed out in Long Island. And I was like, I did some Google search. I was like, yo, be careful, because there's this crazy serial killer out there. And I had no idea about it. And, this was like several years ago. And I didn't think anything about it. And then this came up and I'm like, holy smokes, they finally caught that guy. I thought that they would have caught him. And, I thought they may have. It was just I don't know. I didn't think it was as big as it was. And then I realize now it's a huge case. So I definitely probably look into it. The little things that I do know about it is that I strongly suspect that they used the IgG on him as well. They used a very similar manner of which they claim to have caught him. The fact that he had a green Avalanche at the time. And, at the time this Bryan Kohberger was caught, the other thing that they were pointing out was the fact that he had a white Elantra and that they randomly found his car. You know what I'm saying? And so by a WSU officer, and we find out later that IgG was involved. We know now also that there was some DNA evidence that was left on a couple of things, whether it be hair or whatever, on a burl sack or on the tape or whatever he was using to restrain his victims, and that DNA matched to his, and I think also his wife. And so I wouldn't be surprised if they used an IgG type of situation on that to try to, track him down and figure him out. But the guy was very intelligent too. He was the guy, Rex Huberman, he was a architect, and I believe they found his writings on I guess, like a plan or a manifesto or whatever. Not manifesto, but a plan, a game plan, a playbook on how he would commit at least one or two of the crimes that he was doing. And yeah, that's a little roguey. One of the things that he she likes to run around and make noises. One of the things that gosh, I forgot. Oh, one of the things that he pointed out was that the cameras in the area and things of that nature. And this guy was not a criminal justice student or anything like that. So if he went into that much detail and planning and an understanding of things, Bryan Kohberger, who is a student of that and a PhD student at that, I would think that he probably went through some similar planning as well. But yeah, I may cover it, especially once there's a slowdown period. Hey, Karen D, becoming a newest member. Thank you so much, Karen. Remember the older man who was stabbed and killed in the river, unplanned, first, second, public, here while tubing with friends. Oh yeah, I remember that. They used the crust of pizza he threw away to match DNA on a victim, I believe. Yeah, I remember. Well, I remember that's where they got his DNA from. Just kind of like how they did it with Bryan Kohberger. They try to do a trash pool. So once you get their name, right, you have their DNA on something and you get his name. That's not enough to go arrest him or anything like that. Because one thing, it's not a direct match. It's a most likely. Okay, this is most likely the person that you're looking for. So now you got to go and develop PC. One of the easiest ways to develop PC is taking a DNA off of an item that was thrown away in the trash. And so once they did that, then they can go in and compare it to the DNA that was left on whatever was there. And then that's how they match it. But yeah, that's exactly how they do it. 100%. Mountain guy, yes, he might have done that, but so did 80% of WSC. What did he do? Dylan and Bethany are victims, period. I agree. Oh, man, I want to see. Okay. But as it turns out, her poor judgment hurt Bryan. He ended up looking up the murders before they were reported in that 8-hour window. That's what I'm hearing, man. And me and Dr. Vona have something planned for tomorrow night's show that's going to maybe implicate that as well. We're looking forward to that. What we do know is that somebody did search up Joyce LePage a couple of times while they were in Washington during the times that Bryan Kohberger was in Washington. And the other crazy thing about it is it hadn't been searched in that area since 2020. And I don't think it'd been searched in that area until like 2024. So there was like a 2-year period before and a 2-year period after. Now the 2-year period after. Here we are.
The defendant and counsel for both sides previously identified are present. We are in the public session now. I have my own agenda for what to cover today in the pretrial motion, and so I'm not sure what you have. I didn't receive any specific motions to cover today, other than I think the ones previously submitted by defense related to questioning of the jury. As I indicated, I don't intend to discuss in the public forum what specific questions would be asked of potential jurors, because I think that inhibits the ability to get frank and unprepared answers from potential jurors. And so we may have to cover part of that in a session at the end of the day. I think we can talk about it generally without discussing the specifics, but if we need to go there, that's what we will do.
New prosecutor in the building.
Apart from that issue, as what I intend to do is kind of break down the trial process through stages. And as you have issues or questions about whether how to handle something or how the court handles something, that's your opportunity to ask as it relates to that phase of the case. And we'll just sort of proceed in that fashion. So starting with some general issues, I just wanted, and a lot of this is unfortunately going to sound like me simply lecturing about what I want and don't want. And that certainly is a large part of it, because if you know what I expect, I think it makes your job easier. And so I, particularly where I can't recall whether Ms. Massoff has had any trials with me or not, but I know she's been in front of me a few times, but the rest of you have not. And so it's, I think, important that you get that information straight from me rather than from the sources that you may get from asking around. So to start with, I'm not a fan of surprises, as you may have figured out by now. I want to know in advance, as far as possible, when there are issues that need to be addressed. That includes evidentiary issues. So if you know that you're going to object to some line of evidence, or you anticipate that there's going to be objections to a line of evidence, I don't want to wait until that is offered in the middle of trial for a couple of reasons. One, I don't have the opportunity to look at the issue to the degree that I would want to in order to give you the best ruling that I can. And two, it doesn't give you the opportunity to make the best case for me that you can for either excluding or overruling any objection. And perhaps even more important than all of that, from my perspective, is in what is already going to be an quite lengthy trial, it just extends it. And nothing frustrates jurors more than sitting around in the juror room doing nothing while we're in here doing something. And so that helps guard against that and minimize that amount of downtime that we may have. So we'll have periods, as I will explain to you, before court each day and after court each day, where if you are anticipating issues that are coming up, that's the time to talk about that, not in the middle of the trial itself. I did receive the parties' stipulation regarding how to handle the IGG tip, if you will. I'm fine with that proposed instruction, and so that will be given. I think I'd asked you also to work on instruction related to the use of the terms surrounding touch DNA and other variations about that in the event that I decide to correct somebody about the use of that term. As I said, with respect to the professionals in the DNA community itself, I'm not going to prohibit it in the sense that, you know, I'm going to sustain an objection. What I would likely do is to clarify with the jury, if the parties want me to, about that being simply a convenient title and not meaning to imply an actual source of or method of the DNA being present. And so if you haven't worked on that, please do so to get me an instruction you both can live with. Otherwise, I'll end up
The G's are
drafting one
there.
myself, and perhaps neither of you want to live with.
Last time I asked them, they were off behind the prosecution,
With
just
respect
off the
to
camera.
The model, I think referred to as the dollhouse by Mr. Thompson, has that been produced for the defense to inspect?
It has, Your Honor. It's actually here in this courthouse, has been for a few weeks, and Mr. Herwood facilitated the defense viewing it yesterday.
Okay.
It is available for the court's inspection if the court would like to look at it. And just for the record, to the extent that the model was characterized as a dollhouse, I think that was an inappropriate characterization. It is an inappropriate characterization. If I'm responsible for it, I assume responsibility, but that's simply not appropriate way for it to be described.
That was the
given
defense.
What occurred there and the victims.
I think a better term is simply a model, rough model, given that it is admittedly not to scale precisely. So, Ms. Taylor, any record about that? You had a chance to look at it?
Sure, we did. We were able to bring 2 experts in for our request yesterday, and we appreciated being accommodated while we were here. We do have a remaining question about where the model house will be stored during the course of trial.
Where are you storing it, on the 3rd floor?
Yes, sir.
Okay. So it sounds like it's stored with the evidence vault of the prosecutors down there. And so I suppose if she needs to get access, or our experts do, we can arrange for that as well.
I should have asked a better question, Your Honor. When it's brought in
I
as
see.
a demonstrative aid, I am curious about when it's not being used by the prosecutor or the defense and a witness, where it will sit in the courtroom.
I will find some place not in the courtroom, because I don't want it in the courtroom when it's not being used, but nearby in the event that a witness does wish to use it.
Thank you, sir.
Yeah, the dollhouse was common from
The other
the
thing that I
defense.
would point out, as it sounds like you've been, at least to some degree, working together, and I appreciate that. As you come to stipulations on agreement on things, it's important that those be reduced to writing for your own protection. Because too often what I see is in the middle of, for example, trial, well, Honor, the other side said that they were going to stipulate to that, and then they're not. That leaves me in a difficult position, because I wasn't part of those discussions, right? And so for your own protection, I think it's just important that you get those reduced to writing as much as possible. I did receive the parties' spreadsheets on the exhibits, which we'll go into a little more when we get to the exhibits portion of today's menu. But I appreciate getting that. There's some questions that I had about it generally, and then some more homework to do on it. In terms of the witnesses, I had asked, and I think my law clerk reached out to make sure that we get a description of those witnesses, kind of like if they're who they work for or where they're from, something that will allow me to categorize those on a juror questionnaire, so that they don't just get a list of 300 names, but can say, all right, these are witnesses, these people live in Pennsylvania. These are witnesses that work for the FBI, right? And so that they can put in context those names, which will be result in a more accurate review by them of those names, to see if they know anybody. And I'm not sure if that's been accomplished yet or not. And so if you haven't done that, please get that to us as soon as possible so we can incorporate those. I think the state had, and last I heard, but it's been several days, the defense had, we were still waiting for someone from the defense.
And I believe that that's been provided. My hope is that it was sufficient, because I think it came back and we re-provided it.
Okay, I'll check.
If it's not sufficient, let us know.
I'll check on a break to see where it's at. All right.
Also, guys, I think that the right side behind the prosecution is designated for the victims. So everybody on the left side, they may not all be Kohberger supporters or Kohberger
So, I did,
supporters.
as I indicated,
Obviously, some of them
this
are,
morning,
but they all may
received,
not be.
The defense's proffer regarding alternate
So
perpetrators.
here we go.
That will be sealed
Oh,
per request, I'm assuming per stipulation. And I want some additional information there. What I'd like is by the 23rd, if possible, for the defense to do two things. One, provide me with whatever actual evidence you have that supports those allegations, rather than just allegations. And two, provide for me how it is you believe that what you are offering is admissible. Because it seemed to me much of what you had put in there was fairly potentially fairly objectionable in terms of admissibility. So I would like to see that. And then I would have the state respond by the 6th, which is 2 weeks. And then I would propose a hearing on the 18th.
Sorry, guys, I was writing that down. So they have basically given them, I guess, a couple of names, and the reasons behind it aren't even admissible at this point.
Your Honor, on June 18th, Ms. Massoth has a conflict in the morning, but we could do an afternoon hearing on that day.
Can we do the 20th? The 19th is a holiday, and the court is closed. I'm just not sure whether it can be done in a half a day or in the afternoon or not, depending upon where we're at. That's my concern.
Your Honor, for me personally, the 20th is a little bit of an issue for personal reasons. If we could avoid that date. If we can't, then I guess we can't.
Well, let's, can we start by like noon on the 18th?
12:30 or 1. I'm in federal court.
All right. Let's do 12:30. Are you handling those issues?
Alternate perpetrator. I'm, yes, very involved.
Let's do 12:30 on the 18th.
So the perpetrator, I mean, it just could be just the thing, but I noticed you didn't say perpetrators. So now maybe they only believe one person committed this crime as well. I mean, I think they would have to, right? Because Hippler mentioned in the last one something to the effect that, well, just because you found DNA of somebody else doesn't mean that somebody else could have been working with Kohberger. So now they're going to try to prove that it was one person, and that one person isn't Bryan Kohberger.
Next, I want to go to juror questionnaire discussion. Before I do that, this was that was, as I said, sort of a catch-all category. So I want to ask you if you have questions now, because I suspect it will fit into, if you do, a more specific category, and we can address it at that point. But if you have a question or concern about anything we've talked about thus far,
I agree,
now's your
Blue.
chance.
I believe so, Your Honor.
No, Your Honor, thank you.
All right, juror questionnaires.
Well, what's going on? Oh, the site ain't going down. I've seen this in other cases. Let me see if it's over here live.
No, Your Honor, thank you.
All right, juror questionnaires.
No, it's in both spots. All right. Good to know. Refresh this.
Say like by Tuesday, Wednesday of next week. And then what I will do is, if it appears there's enough flesh on the bone to merit a hearing, we can have that. Otherwise, I will simply provide you back a version that, to the extent it incorporates any of those requests.
Yeah, I think juror questionnaire is usually private too. That's sealed.
Which leads to the next question.
Sometimes.
I think I talked to you about both previously when you were here to visit the facilities. Certainly counsel and the defendant, though it is an administrative proceeding, have the right to be present. But when the questionnaires are administered, but I suggested to you that perhaps your time is better spent in reviewing the questionnaires than watching people fill them out. The process will be such that as we bring groups in to fill those out, those will immediately be scanned and then provided to counsel on a shared drive. And so I guess I wanted to get your feedback on whether I suspect this is a all for one or not proposition.
Thank you, Your Honor. My understanding is we have both agreed that there's no need for counsel from either side to be present during that stage. We'll focus on the tasks at hand.
Okay, very well. Does that accord, Ms. Taylor?
Yes, Your Honor.
All right, very well. So as I indicated, you'll be given access via shared drive. You can do two things. One, you could save those over to a copy over to a drive in which you can make edits, or you can print and make hand edits, or you can just keep track by notebook and juror number. If you want to do the printed
That's my
version, you'll
thoughts
need to
too,
bring
Paige.
your own printer and supplies in order to print those off from your war rooms. The plan will be to take the universe of jurors who are summoned and then scramble them randomly and assign them what we call a scramble number, 1 through 10,000. And then we will bring them in to fill out the questionnaires beginning with 1. So that the questionnaires that you receive first will be the jurors most likely to be in the line of fire, so to speak. Because once we have enough jurors, we'll stop. So that's the plan. Anybody have any concern with that?
No, sir.
No concerns, thank you.
Technically, under the rules, you are entitled to watch the scramble process, which literally involves the jury commissioner hitting a button. I don't know if any of you want to be there for that.
So thank you.
We'll waive our presence
All
for
right.
that, Your Honor.
Very well. I do want to stress the security and confidentiality of the juror questionnaires, as I'm sure you're aware pursuant to Criminal Rule 23. Those are extraordinarily confidential. The copies that you receive will be, we'll maintain a copy, obviously, for appellate purposes. The copies you receive will be returned. The defendants, they're supposed to be essentially attorney's eyes only. I'm fine if you both agree to allow an investigator to see so that they can be doing, whatever online investigation they feel appropriate as you go along. Doing that, in terms of the defendant, his access has to be with attorneys present. In other words, he can't have a copy or whatever to go back with him when he's not with you.
That makes sense, but I have one question for the court. In addition to our investigators, we have 3 that are working on the case. We would request our paralegals be allowed to assist us just with the magnitude of the task. We'd like to have the assistance of our paralegals in organizing and reviewing.
Sure.
And likewise, Judge, we would hope to use our administrative assistants in the process, and they are part of our staff.
Sure, and by court and bar rules, you're responsible for their conduct, and so you'll need to make sure they understand the confidentiality of those questionnaires, and it's really your ticket on the line for their behavior. So that's fine. But I do want to stress that confidentiality because it is part of what I'm giving the jurors on the instructions, is letting them know that there's very limited number of eyes that will review this and that the public never will. So. The plan will be to try to process the first questionnaires. As I said, you'll get them each day and go through them. After 3 or 4 days, we will start to have hearings. Those will be sealed hearings because we'll be going over the questionnaires in detail, in which you folks identify the concerns you have with the questionnaire answers, specifically whether there's a motion or agreement to strike a particular juror before we ever have to bring them in based upon the questionnaire answer, right? And the idea is to dismiss those who are unlikely to be put on the jury because of either perceived bias, knowledge of the case, or hardship. And so, I think it helps everybody if we are trying to agree to that as much as possible. It's the reason that we are summoning as many people that we are, is so that we can really cut through the chaff and get to the wheat. Any questions about the juror questionnaire process?
Sir.
So the next topic I have is voir dire, more specifically. Traditionally, the way, as you know, voir dire works in Idaho is the court first does its voir dire, touching on some essentially statutory kinds of bias or knowledge. And then counsel is given that opportunity. And so much of what would be the court's voir dire, I have incorporated into the questionnaire so as to limit my role in actively questioning the jurors or potential jurors. I may follow up on some of the answers given on the questionnaires if I feel there's a need to. But otherwise, the time will be yours. What I intend to do, and I'll get your input on that, is using a model very similar to the model Judge Boyce and I came up with in the Daybell case, bringing in groups of anywhere from 15 to 20 people at a time, having a general session of questioning by the attorneys, approximately 30 minutes aside of those folks, get through challenges for cause or dismissals for hardship, et cetera, of those folks. And then who's ever left over of that group then would be subject to individual questioning by the attorneys. And so the jurors that are left over will be taken to, for example, the jury room and wait in there. And then we'll bring the jurors in one at a time to answer questions from counsel. The goal is, I'm not going to stop you if you're getting important information that needs to be got to, but the idea is after that more group discussion, the individual voir dire will be more for very sensitive topics, also for knowledge they have about the case from media or otherwise, because I don't want them to talk about it in front of other jurors. And so, and then other topics that you sense were too sensitive to talk about in front of the others. Hopefully we can get through each of the individual jurors in 10 to 15 minutes apiece, but we'll play that by ear. We'll see.
Ask a question.
Sure.
So the 10 to 16 people in the general session, is that going to be the court's few questions and then each counsel has general questions? And just to make sure I understand, then whoever's left from there, we pull in and then we talk about case specific information, the media items?
Media items, correct.
Okay. And would you envision that during the time we talk about media items, I can also find out their views on capital punishment?
Yeah, it may be that you are able to talk about that with the larger group to a degree. There may be some who appear sensitive to that and prefer to talk about it outside, and we kind of play it by ear. So it's not a subject I'm going to forbid from being discussed in front of the larger group. And you'll have limited time with the individual. So, you need to balance how you're going to use that time.
We may have to see how it plays out, Your Honor, but in my view, talking about the views on capital punishment is fine in a bigger group. My preference would be to be able to get the media items, people that aren't going to make it, to let them go before we do that. I think it would save time to have them gone before we do the capital punishment views.
I will answer you, Chloe, about why they
Well,
got
they're
the
not
extension
coming.
here in a
They're not
little
gonna
bit.
stay because of media coverage and those kind of beliefs and views. It makes more sense to have them go before we start talking about something else. My concern is the amount of time and that
Very true.
the media coverage items might find their way into a discussion of capital punishment.
Well, I will make it clear to the jurors that they're not to discuss anything they may have heard in the media during that general session. And we'll play it by ear. If it's not working, we can change it, right? So let's, and this is very similar to the way Judge Boyce had done it. I think it worked well. They got a jury fairly quickly. Now, as much as the attention was in that case, obviously this one seems to have more publicity. But I think that handling it with first going through the general, because we're going to lose people based on hardship, based on, have they made up their mind? Yes, right, kind of stuff. And so we don't even need to talk to them. And then we can get into the issues, or they may, simply give a view of capital punishment in that one that it's clear that they're not qualified, either one side of the coin or the other. But if you want to deal more, if they're hedging or you're sensing some concerns, you can use that follow-up time in individual session to follow up on that rather than trying to do that in the public session. Any questions about that, just in terms of how the questioning will go? So my intent in terms of public access to the voir dire process is that during the group session, victims and defendants' family will be present. A small number of public seats will be available. And then it will be streamed to a larger room in the courthouse for anyone else in the public that wants to watch. It will not be broadcast outside of that closed circuit. Because then I lose control of the recording in the event that a juror's identity is revealed, and then I get all the internet sleuths out there trying to figure out who everybody is. And I want to protect the juror's privacy as much as possible in that regard. And so this does allow for a public access is the right, but also allows the court to tightly control that process. And then the individual voir dire will be counsel and the defendant only.
I may need to go out for that one. I may need to find a way to travel to Boise for that one.
Potential jurors' faces and names obviously won't be broadcast.
Correct. The faces will not be broadcast, and you are to only use their scramble number as their identity throughout this. So they will never, you will never speak their name, nor will I or the court. It'll only be by that scramble number, and the camera view will not show their faces.
The juror number by which we'll name them, will that be on them, or does this court use paddles so that their numbers can be held up when we want
They'll
to
have a
excerpt?
laminated paper, like 8x10 paper that has cardstock laminated that has the number on it.
Using secret jurors or like this tells you what they think
So it'll be
about the
scramble
Kohberger
number,
movement.
not their original reporting number.
Yeah, I definitely got it. I might have to find my way out there for that one,
You
man.
know, my goal is to try to get through 4 panels a day, which may not seem like it's much, but I know from the prior trial that they struggled to get 3 a day. So my goal is to try to get to 4 a day, but I want to get to at least through 3 panel a day. The plan would be is once we get through the number of jurors we need to sit, including alternates and peremptory challenges, plus a few extra in the event something changes before the time we exercise the peremptory challenges. Once we get that number, and let's say that number is 50, that's where we would stop and then go to the peremptory challenges. Does that make sense? Any questions about that?
Just to clarify that I understand it, we'll get enough people that we get 50 that have not been challenged for cause and then
That have been
exercise
passed for
peremptories.
cause, correct. So once you get that, if you will, struck panel, then we will exercise the peremptories. With respect to the number of jurors, prior to Friday, I had intended to use 6 alternates, and after Friday, I intend to use 8 alternates for a total of 20. That's about the maximum that I can fit into the jury box that we intend to use. So
Still only going to take them like 20
20
minutes.
plus strikes, which would be 12 strikes apiece pursuant to rule. Gets us to, I think, 44. And so the plan would be to get, 50 to 55 that have passed for cause to bring back for the peremptory challenges in the event that we lose somebody for some reason in between. Any questions about that process? Okay. So, and then when we're exercising the challenges, what I do is I give you a time limit geared to the number of peremptories that you have. So here, for example, you have 12 peremptories, give you each 30 minutes to exercise those. And it's a chess clock. So while the paper is with you, your clock is running. And once you hand it to the bailiff, it stops running and the other side starts running. Once you reach your 30 minutes, absent some showing of something happened outside your control, then your peremptories are over. Now, that's usually I give 1 minute per peremptory in the typical trial. I'm giving you far more than that here. It shouldn't take that much time, particularly with the number of people that you have keeping track of everything. If you both pass on a round, or let's say the defense passes at the end of round 4, and then the state passes at the beginning of round 5, that ends the use of peremptory challenges, because you both have said to me, by passing consecutively, there's nobody that you want to strike. So understand that that rule as you go in. After the panel is selected, the the jurors and the alternates, which the alternates won't be determined until deliberations, when by lottery, who's ever left will be determined to be the jurors, and the alternates, those who are drawn by lottery to be an alternate. But that group of jurors, and so the 20 will be taken to another location in the courthouse. I will briefly meet with them, simply to introduce to them the people that will be talking to them, which will include the trial court administrator, the jury commissioner, and Judge Cawthon, who will be acting as it relates to this case as the administrative judge during the trial, to help them understand the process that we will use for juror security, for juror privacy, for reporting, and all of that, to answer any questions they have about that process, so they know where to go to ask questions about the process, and sort of, if you will, onboarding them. Counsel won't be at that, nor will I, other than to introduce the people. And then I will leave so that I don't inadvertently hear anything that I shouldn't hear on my own. I want to stress the importance of no contact with the jurors in any way by you, your staff, your witnesses, anybody affiliated with the case. And so they need to be instructed as to that. So if the juror, if you happen to see a juror somewhere else in the courthouse or at the grocery store or at the coffee shop, you're not to even engage in pleasantries. Turn tail and run the other way as fast as you can. If you have any contact with the juror, you need to report it immediately to myself and to opposing counsel, so we can then make any inquiry that we need to.
Do me a favor, send me a
Issued
message,
yesterday,
Chloe, about what that
an
exactly
order
means.
in this case regarding sort of the rules of the road for those attending the trial, as well as an administrative order that I imagine will be on the court's website here, if it's not already, outlining some of that as it relates to outside the courtroom. So my order in this case relates to the courtroom. The order, as I signed as administrative judge, relates to the courthouse at large. Make sure you have reviewed that and make sure your team understand that. There will be portions of the building that will be off limits to the public and to you. So make sure you understand that as well. I think I told you when you were here to look at the facilities, it's important that we know where it is you intend to stay as soon as possible, as well as any witnesses you put up, et cetera, so that to the extent that we ultimately may need to sequester jurors, which once it goes to deliberation, we will have to at a minimum, that we steer you away from whatever series of hotels that we've reserved as potentially available for us to use, that you're not there. So let the staff know if you intend to stay at a hotel, if you intend to put witnesses up at a hotel, intend to have staff to stay at a hotel. Let us know where that's going to be. You will each be assigned a conference room outside the courtroom, and you'll be given a key to it that you may lock each day, that nobody, including janitorial staff, will have access to, where you can keep your papers and files if you'd like, or other materials, and to use to meet with witnesses, et cetera, as we go along. All right, before we turn to the trial itself, any questions about the jury selection process or the jurors?
No, sir.
No questions, thank you.
So
So
the
there-
trial itself,
never mind.
the plan is to go from Monday through Friday with the session with the jury beginning at 8:45 each morning and ending at 3:30. Once we hit a sequestered phase, whether that be, for example, in a penalty phase or earlier in the case, should it become necessary, I will likely extend the hours of the trial to fill up the jurors' days. Part of the reason to give some time at the end of the day is so that they can do the errands of life that they need to do. But if we are hosting them, so to speak, we don't have to worry about that. And I'm sure they'd rather have their day taken up moving forward on the case. So that is the general plan. Counsel and the defendant dressed, ready to go at 8:15 each morning. From 8:15 to 8:45, if there are issues to discuss, that's when we will do them before trial starts. As I encouraged you when I first started this morning about this would be a really good time to discuss anything that you've just uncovered that might be an issue in the case. We will likewise have a period at the end of the day from 3:45 to 4:30-ish to similarly address issues that may be coming up the next day or in the near future. At this time, I do not intend to have trial on October 2nd and 3rd. Because of a previous commitment that I have. I had talked to you before about potentially being gone on the 14th and 15th. As of now, I've been able to make alternate plans. So for now, you should plan on being here for trial on those days. Holidays that I could spot quickly on the calendar include September 1, October 13, and November 11. So those are holidays for which there would be no court, with the exception that if we are sequestered, we may have trial, and we'll address that as we go. Because I can't send jurors home for the holiday, and so we might as well use the time.
I would have assumed they'd be sequestered. A case this big, I would assume
Any
they would
questions
be.
about that trial schedule? Okay. All right, in terms of special needs that you may have for trial, I'm assuming there is no need for us to have interpreters for any witnesses.
Yes, sir.
And then technology needs, be sure that you make sure whatever technology you intend to use works in the courtroom in which we will be. The best way to do that is to contact Ms. Barrios, the trial court administrator, and reserve a time to come down and try it out. I also suggest that you use on your team somebody that is far more technologically savvy than certainly I would have been in your shoes. Perhaps you are, but it's important to have your own IT kind of person there to deal with any issues that may come up. If you have litigation presentation software and it's not working, you might get a short recess of a few minutes to work it out. But if it's after that, we're just going to move forward and you'll have to figure out something else to use. So it would behoove you to have staff there that can deal with that. Likewise, in the event that something comes up last minute and there's a need to redact some portion of audio or video or other presentation, that you have somebody there that can do so quickly and knows how to do so quickly. And I would encourage you to plan ahead to have alternate versions of such things so that if there is a concern that's unresolved going into it, you have version A and version B you can use depending upon what the outcome of that may be. Any questions about technology? In terms of what we provide, it will be a overhead, what we call the Elmo device, which is the device where you set a piece of paper down and it projects onto the screen. And then we have a HDMI link for your computer to present whatever you want to from your computer. That's it. That's our technology. So anything beyond that, you'll have to bring.
Professor, he's going to hate asked if there's a place to send
Let's talk about,
donations. Put the donation box at the bottom. I may
seating in
put
the
something out there
courtroom, council table,
for that.
the trial broadcast. Each side, I think when we toured the courtroom, each side will have two council table kind of put together, which should give you, depending on how closely you want to sit together, anywhere from 4 to 5, maybe 6 seats at that table to use how you wish for yourself and your staff, and in the defense's case, the defendant. As I also indicated, I would provide a small table behind defense because they're not really as close to the bar as the state would be. A table behind you where you can have staff, 2 to 3 staff members. The state will have some room behind the bar, directly behind them for its staff. What I need from you are numbers. Understanding the space that you have in the well. How many seats do you need? How many seats are you requesting and how many seats do you need are two perhaps different issues. But in terms of requesting, this does not include, for example, the victim's family or the defendant's family, but for staff. So apart from the 2 or 3 seats behind you, I'm assuming that's enough for you. For the state, likewise, 3 seats, 4 seats.
We should be able to make that work, Judge.
In terms of reserve seating for the victims, it will be for those statutory victims that was agreed to by the parties. And for the defense's family, it would be those 4 members that were identified in terms of reserve seating. What I would like to do, though, is I suspect that it's maybe that everybody won't be at trial every day. And so what I would like, excuse me, is for those that have reserved seating, in particular the victims, and I should point out I am going to reserve 2 seats for the 2 surviving roommates who are technically victims of the burglary. I don't know whether they would have any desire to be here. I suspect not, given the way they've been treated in the media, but if they do, that they would have seats available. But anybody who has reserved seats, I'm asking that they notify the trial court administrator what their plans are for each week. So if you tell me you're not going to tell the TCA, I would like to know, for example, we're not going to use 3 of the seats on Tuesday. So that we know, so that we can make those seats available for the lottery system or the.
I should tell you that
lottery. It's a
DM and
personal
BF are
system
not
on a
alternate suspects.
computerized basis, but so if we don't hear from you and you haven't made arrangements, we will assume that you don't intend to be here. So it's important that each week you let the trial court administrator know. She'll give you an email address if you contact her, where you can send an email to tell us whether you'll need all of your seats or not that week, and at which days you won't. That goes for both the victim's family and the defendant's family.
And the reason why it's victims of burglary and not murder is because the only other charges was murder, and obviously Bethany and Dylan weren't,
Right
their lives
now,
weren't taken.
The
So that's
plan
why they're a
is,
victim of the
and
burglary.
this is subject to change, to have a reserved seating, I don't want to say reserved seat, a seat selection process by which people can go to a website each day and at a certain time, and it's kind of like buying concert tickets, indicate a desire to have a seat, and the first X number that are available that get through will have a seat. It will be necessary to bring identification to show that you are who you are, or are who you say you are, to get into the courtroom. Again, that may be subject to change. I think the intent is for Judge Cawthon to have a town hall meeting with media in June at a date to be determined later, to go over sort of what that process looks like, so that gets, so the media is aware, and so that then it gets publicized to the general public that would want to be here. My intent at this point is to allow a stream of the trial proceedings controlled by the court to be run on the court's, where, if anybody's watching today, where it would be today, on the court's broadcast page. The views will include counsel table, the podium, the witness stand, and the bench. There will be no production of the video, meaning there'll be no close-ups and zoom ins and zoom outs and things of that nature. It'll be the static views.
At least we'll get to see it, right?
Before the court goes further, when we're talking about the reserved seating for families in the courtroom, if we have some other members of Mr. Kohberger's family that travel and want to attend the trial, can we request an extra seat for a day for them?
Yeah, we probably be able to accommodate a few days here and there, but seating is going to be very limited, right? And so I don't want to extend that beyond the immediate family as a general rule, but if there's a specific day or two where there are going to be a couple other folks in town, talk to the trial court administrator, and she'll see what she can do.
In addition to that, we have one other person on our team that would like to have sit with the victim or with Mr. Kohberger's family. It's not somebody who would testify. So if we could have 5 seats, it's somebody who will just assist them, as the media might try to talk to them
Sure.
a lot.
All right, I don't have a problem with that. I'm assuming the victim witness coordinator will want to be there as well, so.
And Your Honor, as the court is aware, we have, unlike most cases, we have multiple victims here. So we will have multiple victim coordinators to work with separate families. We will coordinate that with Ms. Barrio's office to let her know.
Are you talking about one per family?
Hopefully not like that, but we're
Thank
going to need to split at least, we're going to need to have at least 2 separate groups.
All right, let's try to keep it as limited as we can, just because seats are at a premium, but.
Yes, understood. Your Honor, may I also ask the court in regard to the live stream from the witness stand? I believe that we mentioned this, at least in passing, in our trial brief. State anticipates that we may have witnesses who, for reasons the court articulated about the other 2 victims, surviving victims, that a public live stream where their images could be captured and played games with in the media world. Is it possible for the video of that live stream when they testify to be shut off and just have the audio? We also may have a small number of law enforcement witnesses who also do covert work, and broadcasting their images publicly would be desirable. We will advise the court. We've asked the agencies to identify anybody in that capacity and to specify the basis, which we'll bring to the court. I just wanted to give Your Honor a heads up.
Your Honor, this
That's interesting, and
is
I
very
gotta-
high profile, and we've had people who have expressed reluctance to talk to us and being willing to testify for similar reasons. I did have a chance to speak with the state this morning, and we agreed that what we'd do is take a look at our entire witness list and try to figure out people that might be more sensitive to having their video camera on their face while they testify. And we may approach the court with a stipulation for certain numbers of them.
Well, my intent would be with respect to victims, and I've already indicated, I think the two roommates are victims. There is a compelling interest to protect them. And so just as typically when media is present, they're not permitted to photograph or video victims that may be in the courtroom. If the victim requests it, their face will not be shown during the broadcast. In terms of those that work covert, I gotta see where the parties land on that. If they weren't covert in this case, I'm not sure about that. I'll have to think about that, and you may have to convince me, because I think there is public interest at play here. And so we'll talk about it.
Thank you. Yes, sir.
And as for anyone else, you're going to have to really convince me because of the public's right. And their hesitancy can be overborne with a subpoena. And that's what subpoenas are for. So I'm probably disinclined to do that in general for other witnesses. As you can see, I'm even hesitating with people that may have a line of work that is undercover if they weren't undercover in this case. So other folks who may be shy, probably I'm going to have to weigh heavily the public interest there.
Your Honor, I wonder if the same could be accomplished with a room where there could be a feed for certain bits of testimony to a larger group, and it's still a public open courthouse, and live streaming something that gets captured.
For victims, I would be okay with that.
For a very long time might be different, and I can work with the state and then give the court a little bit more on that, but off the top of my head, that's what I'm thinking.
It's going to have to be a very compelling reason to do it. So aside from victims, while we are open in the sense that the people in the courtroom, the likelihood is we can't fit everybody in there that wants to be in there. And if I start not broadcasting the testimony, the full testimony of people who would otherwise prefer not to, that's going to fill up, that's going to be a large number quickly. And the best way that we have to ensure that the public is accepting of whatever verdict may be reached in this case is for the public to have the ability to see the evidence. So I'm not saying no, I'm just saying you're going to have to really convince me.
Thank you.
That's pretty much a no, though. So Ann's witnesses for Bryan Kohberger, they don't want to show their face
about,
to anybody.
seating,
I wonder why.
or, broadcasting besides what we've talked about.
No, sir.
All right, let's move to then opening statements. Let me start with what you've probably figured out by now. I am not tolerant of argument during opening statement. So if somebody's arguing and there is an objection, it will be sustained. Please don't do it. What I would like you to do is, by about the time that we're meeting again to select jurors, let me know what you estimate the time you need for your opening is. I will then look at that request and give you a time allotment based on consideration of that request. Each side will be given the same amount of time, and then I will hold you to it. In other words, if you tell me it's going to take an hour, I'm not going to tell you you only have 30 minutes, right? But if you tell me you want 5 hours, I might have some questions about that. But if you tell me you need an hour and I give both sides an hour, in about an hour, you're going to hear me say, counsel, you've got 5 minutes left. Use of exhibits or potential exhibits during opening statement. Because exhibits are not pre-admitted, even if stipulated to, there has to be an agreement to show the exhibit during the opening. Hopefully you both work together knowing what is coming in and isn't coming in, particularly where there's an agreement that something's coming in, other than spite, there's no good reason to not agree to it because the shoe will be on the other foot, so to speak, down the road. So courteous typically pays off with reciprocal courtesy. So work together on that. But technically, if it's not admitted, which nothing is by the time of opening, and there's an objection to using it, I would likely sustain it. For that reason, it's important that you, if you're going to use, for example, like a PowerPoint or something like that, that you share that with the other side at least 72 hours in advance so that they have a chance to review it and then work out any concerns they have and lodge any objections that can't be worked out with me, 48 hours in advance, so that I can then look at it and make a determination. If I haven't given you a ruling by that time and you're coming into openings without yet having a ruling, I suggest you have more than one version ready to go. One that is anticipates the objection being overruled and one that anticipates it being sustained. Let me reiterate again, please do not argue during opening statements or in voir dire, I should mention as well. Make a request at the beginning of your opening to enter the well and it will be granted. However, an invitation and permission to be in the well is not permission to invade the personal space of jurors. So understand that and stay a few feet back, at least from the bar of the jury well. If you are going to use a PowerPoint or some other presentation, you need to choose at the beginning of your presentation whether you want the lights on or off, and they will remain that way throughout your opening rather than turning them on and off again. So I suggest you do a dry run based on what the light looks like at that time to see what that looks like, to see if you want it on or off. Any questions about openings? All right. Next, I have witnesses. Before we do that, let's take a break. We'll take 10 minutes and I'll be back. All right.
All rise.
All right, so they just took a break. Let me kind of recap what they talked about and what I'm thinking here, guys. Right here. All righty. So they're on a break. Let me go back to the beginning. Alternate suspects. So apparently, Ann Taylor has only come up with a name or names of alternate suspects. There's an accusation, but no evidence behind it. There was some things that they were able to bring up, but the judge is questioning how it's admissible. Much of it is objectable about its admissibility. The state, they want a response by the 23rd of May, and then they want the state to respond by the 6th, and then they're going to have a hearing on the 18th of June, referencing at 12:30. So that's going to be about, what is that, 1:30 p.m. Central Time, 2:30 on the East Coast. This is when they're going to be doing their alternate perpetrator deal. So it got moved because they had no evidence, and all they have is an accusation against somebody. And what they have with that accusation is not even admissible. So who could they possibly be bringing in? I mean, if they have somebody's name, obviously I was thinking, and I think that a lot of people thought this too, is that they're going to try to blame, somebody close circle, maybe perhaps Jack Decor, ex-boyfriend, but how could some of the things that they're pointing out be admissible? Like the fact that they had just gotten out of a relationship. Okay, were there any text messages? Were there anything that showed violence or a history of violence or any of those type of things between them? It sounds like they were actually on the up and up trying to get back together. So that aspect's probably thrown out. There's also that they're probably saying, well, he lives close by. But how does that correlate with the evidence that there's a white vehicle driving around a significant amount of time, except for the specific area or specific time frame within which that the murders occurred, right? So that's the other aspect of it. And as soon as you hear the sounds from the audio 50 feet away, and Dylan is see somebody walking out, shortly after, there's a vehicle leaving at a high rate of speed. This is a one-way in, one-way out. It's not like you can drive in through the King Queen Road intersection and leave that neighborhood through another area. You have to leave through that specific area. So, what are they going to say? Just the fact that they broke up and the fact that she called him a couple of times throughout the night. There's text messages and voicemails that were left behind. None of it was sounding of fear or being scared. It was more of, hey, let's work things out. As far as Kaylee wanted to get back with him. That's what it was. She wanted to get back with him. And so, like, for a lot of people to think that, oh, okay, she was leaving him. Those text messages leading up to the time that this occurred were, and voicemails were of her wanting to get back, saying we have a dog together, those type of things. So, if you're thinking that the motive is that Jack Decor committed this crime because she left him and didn't want him back, you're barking up the wrong tree right there as well. That's way off the wrong tree. And Paige, she put it down in the comment section earlier. It's kind of weird. How did Jack get a knife sheath with Bryan Kohberger's DNA on it, which is very true. But I question also the admissibility of these things, like as far as how are they going to, point to anybody as anything. So this is just kind of proof to me that there's nothing there. More of a delay, maybe a delay tactic in efforts to try to get this pushed back a little bit further. Doesn't look like it's going to work. Don't look like it's going to work. So they put down some dates as far as a hearing for this. It's going to be on June 18th at 12:30 local time to Ada County, so about 1:30 Central Time. If it's something that is live, I will be definitely going out there, and I'm not going out there, but I'm going to come out here and we'll be doing this again as well. So kind of just go over everything they talked about, everything else. First thing that they mentioned, that this was the public portion of the hearing. It was supposed to have started at 10 or at 9 o'clock local time. I think it started closer to about 9:45. So I'm curious as to what was said prior to what will be there before. I'll see what I can find as far as this perpetrator. Maybe perhaps I can get some more intel before all is said and done. Witnesses' description of who worked for and from for the jury questionnaire. And then they went into the alternative suspects that we just talked about. Then they go into some jury questionnaires and the voir dire for the jury instructions and asking them questions about, whether they agree on the death penalty or not. They brought up the fact that they're going to have a 20 jurors in the jury box. You're 12 regular, and they're going to have 8 alternates, which is something that it's on the higher end of normal. I wonder if he's anticipating some jurors being knocked out. I don't know. They mentioned that there were 12. Let me pull it up real quick. Let's see. Hold on one second. Oh man, I didn't bring it up. So there was there are challenges, preemptory challenges on each side. There's going to be 12 of them that can use to strike the jurors from the panel. I got this from Club. There are no set number of cause challenges, but there are seldom used because reserved for when they think potential juror has some sort of actual bias or issue that will cause them to be impartial. Some sort of prejudice, judge decides. Each side also has a set number of preemptory challenges. The amount varies for a type of case and severity of crime. Here, Hippler said 12. This is an opportunity to strike a juror because you don't want them. They are not good enough for your side. So for whatever reason, I guess the other side cannot object to this, they can strike at least 12 of the jurors on each side. Okay. The trial will be Monday through Friday, 8:45 a.m. to 3:30 p.m. And no trial is expected between October 2nd and 3rd. There's some holidays, but they go in to talk about if there is a sequester that they will not be, that they may end up, if they're sequestering the jury, they may end up taking advantage of the time anyways and having court. So I would have thought that this thing's going to be sequestered. They talked a little bit further on about the lengths and efforts that they're going to go into to try to hide the identity of the jurors. People are going to be in there and people are going to put things out. There's other cases where juror information has come out. I would think that given the efforts that they're going to hide the jury, which is not to show the jury selection, they're not going to broadcast it. They're going to broadcast it to another courtroom inside of that courthouse, a larger courtroom, for people to see it, but it's not going to be broadcasted outside of the courtroom. So that kind of tells me, I'm going to do my little prediction thing, that they're probably going to sequester the jury. So we most likely will see trial dates on those days. Let's see. There were 4 members identified for Bryan Kohberger's family, and they asked for an additional one and a witness advocate or something of that nature. And so the 4 members obviously are his 2 sisters and his mom and dad. They mentioned somebody else coming in. Don't know. They're reserving 2 seats for the surviving victims. And the judge said that he sees them as victims. So when it comes back to this alternate suspect theory that they have, I doubt he'd be saying this if they were being brought up in this alternate suspect theory. So highly doubt that the defense is even going to look at Dylan and Bethany as suspects in this case. I think what they're going to do is they're going to challenge their knowledge based on their intoxication and things of that nature. But I don't think they're going to challenge them as far as having any information or any knowledge or any part in with the murders themselves. And so for all the pro-burgers that seem to like to challenge them and persecute them and everything else in between, even Bryan Kohberger's defense team doesn't seem like that's going to be the case. It seems like it's most likely going to be a challenge of what they saw based on their intoxication level, their sleep, and et cetera, and try to manipulate what they saw and heard versus try to accuse them of actually being a part of this investigation or a part of the murders. So I'm glad that the judge brought that out and he actually mentioned that. Now, the state had mentioned that they wanted to perhaps maybe not record some of the victims' and or some of the witnesses that may be going up there. Not sure their faces. Some of them are covert agents. Now, I remember, and I just recently did this, like 2 days ago. It's crazy that I just recently did this. I went and I was looking at some videos from very early on. And one of the videos that I was looking at, I might still have it up here. But one of the videos that I looked at was when the Cowboys were in there in the middle of the night. Remember that? And there was a video, News Nation was outside, and there was a group of guys coming out in plain clothes, clearly some sort of law enforcement agency. They came in 2 vehicles. One was a van. I believe the van had Washington State plates. And so News Nation was trying to articulate and speculate that there was a good possibility that that vehicle was FBI. But if you go and watch that, nobody talked, nobody said anything. And if you watch the video itself, there was a specific person wearing a lighter brown, like sweatshirt, cowboy hat, jeans. I mean, he was like covering his face, and he walked around the van. And then there was another guy in a darker sweatshirt, also kind of doing the same thing. And when he got into the van, I thought it was really weird. In fact, I have it put to the side, and we'll watch it maybe this weekend now. But I thought it was really weird as that officer or that agent was trying to slide into the van. Like they were literally closing the door on him, so that way they couldn't get any view inside of that van. And I thought to myself, I wonder if there's somebody in that van that they don't want the media to see, whether it be Dylan, Bethany, or somebody else that may have been in there, or whatever the case may have been. But now I think based on the way they were acting, these were some of these covert agents. And I think that these were the guys that probably were maybe timing some things, trying to figure out which direction to travel, this person may have came from. Because if you go back and watch it, they all come in from the kitchen and they go straight to Xana's room initially. And the video cuts out. I'm sure there's some other video out there that is more, probably gives you a better understanding of what they were doing that night. But that's all I saw of that video. They kept cutting back and forth and back and forth. And I'll show it this weekend. But to me, once they said covert agents, talking on the stand, that's initially where I went to. I was like, all right, so these are the guys that were there. They probably do some undercover type of stuff. And, they were helping out in this scenario, probably doing some of the timing aspects of things. Because at the end of the day, they were trying to figure out, what happened before Bryan Kohberger was ever found, right? They had the scene, they had the bodies, they had the autopsies done, so the injuries were documented. So they went in there, and at certain points, whether it was that moment or another moment before they locked it up and boarded it up and eventually, knocked it down, they went in there and did tests to determine how long it would have taken to have committed this crime. They would have done this early because they would have wanted an idea of the kind of person that it would have taken. The amount of time is going to tell you that, 2 to 4 minutes is what they came up with. And that accounted for every slash mark, every mark that was, every injury that was attributed on the autopsy per the documents. And it was only 2 to 4 minutes. And so, as I mentioned before, the hearing started. If you go back to the Linda Lane footage, that vehicle's pulling up at just before 4:08, and the video from 11:22 or 11:12, I'm sorry, shows that vehicle leaving at 4:20 and closer to 48 seconds, so closer to 4:21. And so you're looking at between 4:08 and 4:20 that he's in there. Granted, Dylan's calling Bethany at 4:19 saying she saw somebody, and then that person had left or was walking towards the kitchen to leave. That was at 4:19, meaning that situation had just occurred. So it was probably about 4:18 and some change that interaction is happening. So you're looking at 2 minutes outside where he's probably cleaning up himself or changing out of the clothing that he had, or maybe perhaps he's jumping into something else. Maybe he's jumping into, I don't know. I mean, I never thought of this, but is it possible that instead of him jumping out of something, he's jumping into something, into like a hazmat suit or something else? You know what I'm saying? I mean, there might be something on the ground that he's jumping into, zipping it up, and that way that's preventing the blood and everything else from his body getting onto anything else. So high possibilities there. He doesn't necessarily, that could be very well what why he didn't get any DNA anywhere. He may have put himself in something that contained that DNA from getting out. So interesting. I never thought of that. Want to say thank you to Gritchinario for becoming the newest YouTube member. Let's see. Space Junkie says, question for Daniel. Steve G mentioned that the killer may have wrapped the t-shirt looking around the knife. Maybe that was DM that saw. Steve's choice of wording is interesting. Well, I mean, it was referencing the vacuum cleaner, and I think he was just speculating. I don't know how. I don't think anybody told him that. From my knowledge, I asked him this a long time ago, so maybe this has changed since then. But they hadn't had any real conversation with Bethany or Dylan. At the time that I had asked them if they had spoken to him. And so I don't know, maybe that's changed since then. But I don't know if he was aware of that until that came out. And so that very well just could have been speculation on his part. Kikola comes in with a $4.99 super sticker. Thank you so much. Jen McVick comes in with a $1.99. Thank you for your awesome coverage as always. I appreciate that. Thank you so much. And Daniel, is there a place to send it? Yes. So down here, I know I saw your comment about the Airbnb. Yeah, hit me up on the Discord. I'm not. I don't want to. We'll talk about it there. That sounds. I appreciate it. I really do. But hit me up on the Discord. Let's see. The only way he gets delayed is if he fires his attorneys, which I wouldn't put past him. Yeah, I wouldn't put it past him either that might be the case. Started watching late. I'm confused. Defense. Oh, yeah. They extended it because he doesn't have any evidence of it. And the evidence that they do have is inadmissible, apparently. Do you think that Xana refrained from screaming for help in order to save her roommates' lives from the perp? Been wondering why she didn't yell for her help. I mean, there's a good chance she was just frozen in fear. It happens a lot. You'd be surprised how more often that happens than anything else. A lot of people wonder or put themselves in a position that they've never been in and think of what they would have done. And in reality, it's hard. It's hard. I mean, pressure, stress, all that takes a huge role in a person's decisions and thinking and cognitive thinking and things of that nature. Very, very many times does a person have to train for moments of high pressure and stress to be able to act accordingly during those moments. Many times, if you're not training yourself to do something like that, like in law enforcement or whatnot, or military training, then you probably, most likely, most people don't act in the way that they think they would have. It's kind of like when you're watching like a TV show or something of that nature, and all the answers to all the questions, and then you think to yourself, man, how could they get on there, blah blah blah. And then if you ever find yourself on said TV show, you might be finding yourself blank on a couple of questions yourself because of the pressure of the lights and the camera and everything else. I encourage anybody who questions how people would act to come on the show and let me question them in front of the lights, camera, with the camera on, and I'm going to ask basic questions just to see how much pressure and stress can add to a person's thinking and ability. And we'll see how good people are. Now, if you've been doing YouTube for a while or whatever, and you're used to being on TV, that might be one thing. But if you're not, that's a different story, right? And these girls here obviously weren't prepared for something like this. So, them freezing, them not saying or screaming or doing the things that you would have expected somebody to do in those situations probably attributes to just the fear aspect of it. Do you think Xana? Oh, sorry about that. Same one. Mountain Guide, OJ and Casey Anthony lurk in my mind when you think someone is very guilty. I get it, but there's some context that goes into play. With OJ, there was a lot of, what's the word I'm looking for? There was a lot of issues going on socially in America and around that time. The Rodney King situation had just occurred. There was threats of riots. The LA riots had also happened. So a lot of people were kind of nervous about that aspect. And then you also had law enforcement in that case who were made some disparaging remarks there as well. So, used racial slurs, I believe. I haven't seen the entire trial. I've only seen part of it, and I've seen probably just the Netflix special on it. So forgive me for not knowing everything about it, but there was some other aspects to it. And with Casey Anthony, there was a lot of, well, the first thing is the body of that little girl wasn't found until much later. So that played a huge role, evidence, things of that nature. Also, I think that the prosecution in that case, I think they went in there a little bit overconfident and really didn't display what they needed to. And to be honest with you, I honestly don't know why she was found innocent outside of those things. I think that the loss of evidence there is pretty key. I mean, they proved that she was lying a lot. Yet a lot of people believe her. I mean, I've seen other cases where people get caught lying quite a bit and they still believe the defendant. It's wild. But yeah, she was lying a lot. And so I don't know. I didn't watch that trial also in its entirety. When all those, true crime is something new for me, guys, to be 110% honest with you. I've only been following it for the last 2 years. Now, I was a law enforcement officer, and so I have a lot of experience in investigating and, police work and things of that nature, but not when it comes to like specific cases that I have not looked into, if that makes any sense. But I think that there was a lot of other reasonings behind why Casey Anthony or OJ Simpson got off. And I don't see those being anything near a situation here with Bryan Kohberger. He just referenced the jurors not being on camera for the live stream, like he will allow it to be broadcasted. Well, he's going to allow the jury questionnaire and stuff to be broadcasted within the courtroom, but they're not going to show the jurors. DT, who could she possibly have as a suspect? It's a good question. I would assume that you're probably thinking the ex-boyfriend, Jack Core. Maybe they bring up. I haven't heard anything about Sigma Chi that validates anything that happened there. I know there's some rumors out there that somebody got into a heated argument with Ethan. Ethan accused somebody of being on roids, etc. The only problem is this crime isn't consistent with somebody losing their mind with roids, right? Rage. This is more consistent with somebody methodically going in there and planning out this and carrying out his plan. Roid rage doesn't usually, somebody driving around several times isn't an indication of rage. Somebody breaking in without forced entry isn't an indication of rage. Not leaving DNA behind or dressing up and dressing down and those type of things, turning off your phone. Those aren't an indication of rage. So to me, it don't fit the scenario. And like I said, I asked Steve and he says that he's not heard anything at all that it could validate any of those rumors that there was something that happened at Sigma Chi. And I talked to Kelly from What's the Obsession, who has the connect with some of the boys from the Sigma Chi fraternity, and they also deny that anything like that happened. Hey, look at that. Page has become the newest member. Welcome to the membership page. Yeah, they said 10-minute break. It's been over that. That's for sure. Oh, thank you, Mommy Megan. I appreciate that. Steelers fan is in the house. Hoping everybody has a great day. Thank you. And what I'm going to do is I'm probably just going to clip everything I just said right now. 221. To explain instead of having to go over it all over again. If you have any questions or comments that you want me to see, the super chats catch my eye. They automatically get starred. Putting a couple of stars before your comment or question help me out as well. Oh, Nikki, I appreciate that. No, I'm late, but I sent Rogan a birthday. I appreciate that. Thank you so much. Thank you everybody who sent something to Rogan. We truly appreciate it. We still getting things in, and so we still plan on putting something together for everybody. I plan on doing a few things. You know, now that I got everybody's attention on it. I got this electric scooter thing that I plan on showcasing and using, and so I might do a little review on it for you guys as well. It's going to be just a regular video, something on the side. So if you guys are interested in that, keep your eyes out for that. I got some car parts that I want to put on my car. Might record it, might not. I have no idea. You know, I know everybody here likes the true crime stuff, so that's my niche. But you know, might do some other things. Just, you know, in between time. Mountain Guy says, I think they will use the unknown DNA and try to link it to alt suspects baseless. I think they're going to try. I definitely do think they're going to try to bring that up. I wonder if he will be on standby. I'm doubting, but would love to see him. It would be interesting to see his actions. If who would be on standby? Let me know who you're talking about. I had a loved one taken by someone who had a combo of roid rage and PTSD. It was violently explosive. He didn't quietly slither in. Unfortunately, I'm sorry about that, Mama. Moondust, that's unfortunate. And yeah. I mean, rage is to the point where somebody goes in there and commits a crime like this is there's evidence of that. You know, there's evidence that's left behind. And I don't see that here. This is more evidence of a methodical serial killer offender, to be honest with you. Saw your comment video about the possible launcher park near the residence. Definitely makes sense. That could be his car. I think that could be his car. The 911 call we talked about at the beginning of the show, at the top of the show. The 911 call was from a female. We uncovered that. So he may not have called 911, but Dateline was pointing out something. Dateline was saying he was searching the internet, and then at 5:19, the girls posted a picture while he's on the internet. And then later there's a 911 call, and you can see some things. Now, maybe, I was, trying to connect the dots there, and I thought maybe they were trying to say that he made the 911 call. Now I'm thinking maybe they're just saying that he saw the picture and went out there. And if you go back there and look, there's a white launcher on the back park there. So it's interesting. It's very interesting at the very least. We know he was out there a few times. If he was going to be out there and we was surveilling the house, that area where that car was parked would have been probably one of the best areas to get a good vantage point. And you see all that brush and stuff, you probably see through it. People hanging out down there, you got to look up to see it, look through the brush to see it. So, you're probably, if you're not paying attention, you're probably not even noticing somebody's back there sitting there watching you. You know what I mean? But thank you, Stephen. I appreciate that. Is it back? Not yet. They're still on a break. It's crazy and long break. They said they were taking a regular break. They said at this point we'll take a 10-minute break, and it's been like 30 minutes. It was 2:04 when I started breaking things down. 2 hours and 4 minutes into the broadcast, we're at 2 hours 33 minutes. So I don't know. It's a lot longer than 10 minutes, that's for sure. Let me refresh it. Hopefully we're not on something.
You don't have to give notice of those exhibits. You don't have to anticipate that, in other words. Now, this is not a remedy or a right that I'm likely is going to be resulting in exclusion of evidence. It is something that you're going to have to deal with me if you're not complying with it. And I will figure out something to make sure that you do, although I don't expect it will be a problem. You should know what exhibits you're going to use, and there's no real secret here. about what exhibits go with what witnesses. And I say that because there's always going to be leeway where you have an exhibit that you forgot you need to use, or a witness testifies in a way that you now need to use another exhibit. So, there's leeway there, but giving the other side a general idea of the key exhibits that will be used so that they can review those to prepare, I think is fair. The corollary to my use all the time that we have is don't filibuster. I will give an example that I have used, that I have violated my own rule in the past. When I was in your shoes, where I had an associate handling a witness who the next witness was going to be the client, and we didn't want to get to him that day, and he kept turning around thinking he was done, and I kept going like this, meaning fill up the time. Don't do that. Use the time efficiently, but don't filibuster. I've learned to come, as a judge, you sometimes feel like your client is the jury in some ways, right? You want to make sure that that they are comfortable. You want to make sure they're treated with respect, and make sure that things go as quickly as possible for them. And so I've come to respect that. And so I tend to want to make that happen as much as possible. So, don't waste their time, either by having gaps that we can't fill or by filling it with stuff we don't need to use where we could be going to another witness. The lawyer handling a witness, if that is the lawyer handling on direct or the lawyer handling on cross, is the lawyer authorized to speak on the issues related to that witness's testimony at the time it is being offered? And so that is the only lawyer that's authorized to speak about that witness. So if there is a sidebar, only the lawyers handling the witness need approach. If it's specific to that, if it's more general and I need to talk to more of you, I'll let you know that. But I don't want the whole caravan up here for those discussions. Likewise, please do not stretch the shirt sleeve of the lawyer who is handling it by the other lawyer constantly pulling on their sleeve and writing a note and saying, don't say it. They'll get it. Just let them do their job. I'm assuming that there is, based on our prior motions, agreement. Well, I'm assuming at least one of you would like to exclude witnesses pursuant to 615. Because if that's the case, then they will be excluded, generally speaking.
It was the state's expectation that that's what would occur, and that's why we raised with the court earlier on the specific individuals that we've agreed could stay even if they haven't testified yet.
So 615 is one of those rules where if one side requests it, it's granted as a general matter. And so I'm assuming that we're going to be using 615 to exclude witnesses except those excluded by or excused from it by the court. Or you can agree not to use 615.
About experts, though.
Right.
Experts being allowed to view other expert testimony.
Correct. Yeah, experts are generally excused from 615 because part of what they rely upon is the testimony of other experts. Part of what they rebut is the testimony of other experts. So experts generally are excluded. The parties, or in the state's case, a designated party representative, such as a lead investigator, is typically excused from it. I've already talked about the defendant's family in another ruling, and crime victims are excluded from it.
I want some further clarification with our experts.
And I
know
think,
that-
I think you guys agreed that your investigators would be excluded from it as well.
We did make that agreement. I think that may have even been in writing.
Yeah. I'm sorry, I didn't mean to interrupt. I would just had that thought. I didn't want to lose it.
So that's okay. I know the court has talked before about the live streaming and being mindful that witnesses not watch the trial when they're outside of the courtroom, just like they couldn't inside of the courtroom. What I want to know is with experts who are allowed to be in the courtroom, can those that are far away watch the live stream version if they can't make it to Idaho?
Mr. Thompson? Do you have any objection to that?
No, that seems to make sense, Your Honor. And I understood that the court was going to give an admonishment, acknowledgement from witnesses as they appear.
Bailiff, could you provide one of these to each side, please? This is an affidavit that each witness will have to sign, and you hand to me as they are going to the stand when you're called by them, specifically declaring that they have not watched the live stream. This is for witnesses who are excluded or otherwise consumed media about the testimony or evidence presented during the trial. That's not the, I'm not wed to the exact wording. So if you have wording suggestions, I certainly will listen to them, but that is the gist, is that they will provide such an affidavit each as they come to testify. Any concern with that?
Not with the wording at the moment. A question of clarification, though. If the case should reach a phase 2, does this admonition apply to those potential witnesses for phase 2?
So a witness who is only a phase 2 witness
Only a phase 2.
and they attend phase 1. Is that what you're asking?
If they watch or attend any part of phase 1.
Well, the problem with that is that phase 1 is also part of the state's phase 2 evidence, as is the defense's, right?
And I think that would support the need for them to be able to know it if the state's going to rely on things that.
Are you talking about experts?
Experts and possibly lay people too.
Oh, explain to me why lay people should be excluded from it.
I don't think they should be excluded.
So you think they should not be permitted to watch the trial?
I think I've got some double negatives going on. I think that if we get to a phase 2, I don't think that those witnesses have to be excluded from paying attention to phase 1. I think the protection for phase 1 is separate than phase 2 because of the rules of evidence that apply to any phase 2, the lack of them that apply to phase 2, and because the state's going to rely on what was in phase 1. So yes, experts and some potential lay witnesses as well.
Mr. Thompson or whoever wants to address this?
Our initial inclination is to leave that to the court's discretion. I think the whole purpose is to avoid prospective witnesses altering their testimony in some fashion based on what they've seen going on in court. That's the danger. I don't know why phase 2 witnesses should be treated any differently than phase 1 witnesses.
Well, what I'm going to do is, I'll give you a chance to each submit something within 7 days in writing on that, and I'll look at it so that you can give me any authority that you might come across related to that issue. Give me a chance to think about it further, and for the two of you to perhaps talk to see if you can understand specifically who you might be thinking of, to see if the state has a problem with that. Counsel who calls a witness, unless it's clearly an adverse witness, in which case counsel needs to notify opposing counsel that they have not admonished that witness. But otherwise, counsel is responsible for ensuring witnesses are aware of orders in limine, otherwise clearly off a testimony that is off limits. Make sure they understand, the Rule 615 requirements and the fact that they're going to have to sign an affidavit subject to the penalties of perjury that they have not watched this stuff. So it's your responsibility to make sure that they're aware, because when they don't comply, I'm going to be asking, why did you make them aware? While we were talking about the jury, I failed to give you the juror affirmation that will have to be signed by the jurors each day. Let me give you a copy of that along the same lines. So that is an affidavit each juror will fill out daily, indicating that they have not violated the court's instruction or otherwise been exposed to testimony or information about the case outside of the trial itself. If I exclude evidence and you need to make an offer of proof, the opportunity to do that generally is when the jury, when we're not working with the jury, such as the morning session or the afternoon session, so that you can make that record as best as possible. That can be done typically by simply making an oral reference to what the witness would have testified or what the evidence would have shown had it been admitted. Okay, I think the rules are pretty clear, but some judges may have more leeway than others about objections. Let me explain to you what my expectations are regarding objections. So objections to questions or exhibits should be stated simply and without argument. It should not be a speaking objection. So for example, an objection, a proper objection might be, for example, objection hearsay. Objection foundation requires a little more. As you're probably aware, there's case law that is an insufficient objection. You have to identify what is missing from the foundation as part of your objection. If you think that doing so would put information in front of the jury that you're not certain I'm going to allow, please ask to approach. I tend to be a rather quick on rulings, on objections. I've been known to, testimony objection overruled, sustained immediately, without even giving you much of a chance to express your concern greater, because I can usually anticipate what the potential issue is and whether or not it's an issue. That said, if you think your ox has been gored and you need to address the issue more, either to have a record or in order to perhaps convince me that I'm maybe looking at it differently than what you anticipated or than I should, please just ask to approach, and then we can have a discussion here at the bench about that. If you need to make a further record for any reason on an objection or in response to an objection, simply ask to approach and we will have that discussion. I'm sure by the end of the trial, we'll have to replace the carpet from the trail leading from counsel to the bench, but that's fine. As I've shown you before, the court reporter will have a device like this that will allow her to hear through her earphones what we're saying. There will be white noise that's played in the courtroom so the jury and others cannot hear what we're talking about. There will be a physical barrier that blocks most of the view of the jury from what we're talking about at the bench that's rolled out so that they can't see. And we can have fairly fulsome whispered discussions here at the bench about that, whatever the issue may be. I have found in, doing this for far longer than I care to remember, that when I send the jury away to hear argument on an objection, what might take 3 minutes to have the argument on takes 12 to 15 minutes to get the jury back again. And then we lose a lot of time throughout the day that way. And so my preference is, as much as possible, to have those discussions here at the bench. Now, if it's a very significant issue that requires much more legroom, so to speak, to talk about it, then I will chase them out of the room, but I prefer not to handle the more routine stuff. One of the things about, I've had counsel before who confuse the idea of the need to make a record with the need to get my ruling and then offer a rebuttal to it. That is not making a record, that is making a rebuttal. And at least until it goes over to State Street, I get the last word and not you. And so
Doesn't it look like he's talking to Ann Taylor there?
Generally afford that opportunity. So if after I rule and you tell me you need to make a record, it truly needs to be a record on something that for some reason you were unable to make when you had the opportunity to do so, and not simply to see what my ruling is and then try to pick it apart.
And there was no baby in the court. That was my baby. She was snap time. I got my sister-in-law babysitting for me today.
I will reiterate what I started with is I don't like surprises. If you anticipate an objection or you anticipate objecting to testimony you certainly know is coming, let's talk it over before the witness hits the stand, before the jury's in the box, so that I have as much time as possible to be prepared so I can give you as best a ruling as I can, and so that you can make as best an argument as you can. If you anticipate the potential impeachment of a witness by prior testimony, whether that's grand jury testimony, whether that is transcribed witness interviews, whatever it might be, please get that to me before the witness hits the stand, and preferably towards the start of the trial, so that I have that available so I can have read it before the witness testifies, so that when you then ask to either impeach or to refresh recollection or whatever it might be, I will have read that testimony. Don't be mistaken in your belief that I have all that testimony. If it, for example, happened with Judge, I don't necessarily have all those transcripts, so get them to me. Or if I do, they're in one of 100 boxes somewhere back there.
Your Honor, if they've been supplied with exhibits and the purpose was just for that, will that be enough for the court, or should I have an extra transcript at the start of the day if I think I need it on paper for it?
So let me know as far as advancing possible, and I will have staff look for that. But otherwise, it's probably safest just to provide me an actual copy of it. While I'm thinking of it, because I'm in my mind envisioning the materials from grand jury that we have here, the state did file a motion to get back its exhibits for use at trial. I assume there's no objection to that.
No objection.
Mr. Thompson, if you may make arrangements with staff here to get those while you're here, okay?
Yes, sir.
I assume you have replacements you have or will get to me for those.
And actually, we had a procedural question we were going to ask the clerk. I'll ask Your Honor.
Clerk probably knows better than I do, but I'll go ahead and try.
We can do one of two things. We can either get together a set of photographs or copies of the exhibits and exchange those for the exhibits, or take the exhibits, document them, and then give the clerk what we've documented. We're happy to do it either way.
Well, my only fear is that you take the exhibit and then I don't know what the record is of what it actually looked like. Not to suggest that you would be involved in any chicanery and switching something out, but just trying as best I can to preserve that record.
Understood. So we probably will not pick them
Okay.
up on this trip, but we will make arrangements to have that done certainly well before trial.
Very well.
Thank you, sir.
There's no closed caption.
Speaking
I wish
of,
there was, but since it's live, they won't put it.
I'm not fond, and you folks know that by now, of making accusations against opposing counsel that are not well-founded and supported by specific actual evidence. I know that you can get along, but I also know that over the course of a trial, particularly a long one, tension rises. And so I remind you of that to be professional. Don't talk to each other directly when we're in court, right? When the session's going, everything goes through the court as you know, the protocol with courts generally is. Refer to each other by professionally, Ms. Taylor, Mr. Thompson, not by first name while we're on the record. Again, avoid making accusations that you don't have the tickets for, or the receipts for, I should say.
Bring your
Under no
receipts.
circumstances should you make such accusations in front of the jury.
I like this judge. I've seen other trials here recently that are all over the place. They're out of control. I like
It's a long
Judge Hippler.
trial, so as much as I want you to be prepared,
Hold on. I need to refresh this. I now know what I need to do when this
Flexible.
happens.
and a witness who's flown in that needs to get out again at the end of the day. And so it may be that we need to stop one witness's testimony to get the other witness in and then pick the other one up. As long as there's no clear prejudice from that, I'm generally flexible in allowing that so that we can accommodate that. And I ask you to both be accommodating to each other in that regard. All right, any questions about witnesses' testimony?
Just one, it's kind of a takeoff of what the court just mentioned. We have at least one, maybe a couple law enforcement witnesses in particular who have testimony relevant to different stages of the case.
Speak
and
up.
Our intent, with the court's permission, to call them at different times instead of trying to figure out how to call them once and have them talk about what's going on at this stage of the case and then what may be happening next week with the case. Is that acceptable to the court?
Well, let's start with whether it's acceptable with Ms. Taylor.
Your Honor, I don't know that I have a strong objection or really any business in telling the state how to put on their case. That feels really cumbersome to me. I was hoping for leeway the other way when we would call a witness ourselves, but they're a state's witness. I'd hope to have a little leeway to do all of my examinations so they didn't have to come back. I would otherwise defer to the court.
Certainly, if you're somebody's on your witness list, if you want to go beyond the scope of direct as part of effectively your case in chief in advance, I don't have a problem with that. And so if it's going to save bringing another witness back, I don't have a problem with that. I don't have a problem if it doesn't get too cumbersome. If, you know, if we're having a law enforcement talk about a broad area of one phase of the investigation at a time, that's probably okay. But, you know, having them come up and narrate between every other witness is probably too much. Then the question becomes is how do we handle cross-examination? And basically I will defer to the defense on that or the other side on that to the extent that we allow, which is, do you want to cross-examine about the information they just presented now? Or do you want to wait until their last presentation and cross-examine about everything? And so
That's fair.
That'll be up to you.
That's fair. And that was fair by Ann Taylor to bring that up too. I
That
mean,
said,
but
then,
the
I
fairest
guess
thing
I
I've heard her
request
say.
that the state let us know when they call a law enforcement that's for a limited purpose right now, but is coming back for another purpose.
Yeah, they need to let me know that as well.
Yes, Your Honor.
And the reason being is you might want to
If
talk
you
about one thing
don't,
and evidence in another
Let
way.
them
And
know that. And, you know, well, either way, it's your responsibility to ensure that they're back at some point available to the defense so that they can cross-examine, even if you decide, oh, I don't need them anymore. You know, you better not send them on an airplane somewhere where they're unattainable, because the remedy may be to strike all of their testimony as a starting point.
We
very
would
stern with the,
anticipate asking
with
court
the
and
state as
counsel
well.
if this witness may be excused if we're finished with them. And then I would give Ms. Taylor or other counsel an opportunity to let us know whether they still need that person.
Okay. Likewise, when you look at each other's witness lists, talk with each other and then write it in, get it in writing so we have it as to whether or not, for example, Ms. Taylor will need subpoenas to witnesses you have on your list that they want to also call, or if the other way around, you need subpoenas for their witnesses, or whether they will essentially agree to make them available. Anything else with respect to witnesses before I move to exhibits? Okay. All right. So I did require a meet and confer for you to go over exhibits, and I got those, and I appreciate the start that you have on those. There are a number of exhibits where there's appears to be, I can't tell. So for example, there's an objection to, for example, relevance or hearsay. Part of what I wanted to know though, to start is, regardless of whether it's ultimately admissible for those reasons, is there an objection to authenticity? In other words, I want to make the trial go as quickly as possible, you know, avoid the need to put on a bunch of witnesses simply to say, this is what this is, and they don't really have any substantive discussion about it. They're just authenticating a document that if we were to be honest, there's no dispute that it is what it is. And so I may have you go back and look at that and add another column to the list, which is objections to authenticity.
That's like the purchases of the K-bar knife, et cetera. Et cetera.
Some of the stuff, key actual evidence items, you know, whether that's DNA or whatever it might be. Obviously, the defense is entitled to put the state to its burden with respect to chain of custody and all that. So I don't expect that. But on some of the other stuff, you know, certainly to the extent that we can agree that if there's no good faith basis to contest the authenticity, then let's try to do that for everyone's sake. In that vein, I know the state had to withdraw its request to have certain documents self-authenticated to go back and do more work. Where are we at on that?
Ms. Jennings can speak to that, Your Honor.
Your Honor, I believe that we've submitted all of the certificates of authentication for all the exhibits we plan to introduce that way.
Okay. And you submitted those to the defense to review? And Ms. Taylor, are you going to respond to those?
Your Honor, we did. We met with the state last week, I believe, or the week before, and we discussed some of those records. There were some issues with them. Ms. Jennings provided me with a thumb drive, and I don't know if those have corrections on them, but I'll continue to let the state know what we think, if we continue with an objection or if we're satisfied that the rule's been met.
Okay, if you could get with each other and then provide me I didn't study the exhibits that I got a day or two ago, or the spreadsheet that closely, but make sure I'm aware specifically of which exhibits there is no objection to the self-authenticating or otherwise not an objection to authenticity. Doesn't sound like we're going to need a hearing on that, at least for the time being, though.
Not that I'm aware of now, but certainly we'll keep our eye on it. I can alert the court, and if we can squeeze it into June 18th, that's possible. Maybe we
Sure.
can start that at noon.
Okay. And then I would certainly caution, at least because the state goes first for now, I'll say the state, that, belts and suspenders are good ideas when it comes to trial. So I would have my people I need to authenticate things under subpoena, just in case. Especially if they're out-of-state witnesses, because that's not something you can do overnight.
He just wants this case to be, or this trial to run smooth. And he's letting the foundation
The
for
methods
it.
of displaying evidence to the jury, generally there's three ways to do that. One is by putting it on the Elmo and projecting the physical document, whether it's a writing or something else. The other is if it's a writing or something else, using litigation software of some kind to project it through the computer. And the third is passing it through the jury. That last one is the one I want to avoid as much as possible because that just takes too much time. So try to use the other two approaches as much as possible. Now, there are going to be some physical objects that it may be important for the jury to see, and I get that. But in general, photographs, things that are in writing.
I know what to do. Get it done quick. Don't take long for me to learn something. When it freezes, just refresh it. I wish I knew what he said, though.
So oftentimes, and hopefully that's what you're doing, there's an agreement in advance stipulation to admission of exhibits. I generally don't allow pre-admission because what I find is that I admit all these documents that then are never addressed during the course of the trial. And I don't want a bunch of exhibits to go back to the jury that they have no instructions on, that they've had no question and answer with a witness to explain what the relevance of those things are so that they can just go back and use to justify whatever position they want to have from them. I think that's dangerous. And so the process, if there's a stipulated to exhibit, would be to, just as you normally would, identify it with the witness, or not even necessarily doing that. You're going to use exhibit 6. Witnesses on the stand, and just say, Your Honor, I'd like to go over exhibit 6 with the witness. I understand that the defense has no objection to this. Look at you. That's correct. All right, exhibit 6 is admitted, and then we go from there. On voluminous documents, if possible, try to avoid sending the whole thing back if there's only a small part of it that's relevant. If that's not possible, let's highlight the parts that are relevant and maybe even explain through the witness whether any of the rest of it is relevant, right? So that they know what to look at. In that same vein, if you have a voluminous exhibit and there are, say, 5 or 6 pages from it that are important, what I might suggest is the exhibit be, exhibit 47, and then you have 47A, 47B, 47C as marked exhibits. They go with 47, but they're separate exhibits so that the jury can keep those in mind, and we can keep track of those. It looks like from what I received, the state's using S- number for its exhibits and the defense is just using numbers. Is that accurate?
It is.
Hopefully that won't get too confusing for people. Where we can, what I also suggest is that the defense is going to use as part of its case the same exhibit that the state has used and admitted. Let's not admit another copy of the same thing. Let's just use, so I like to say, the parties don't own the exhibits once they're admitted, the court does. And so there's no proprietary interest there. So if you already have it admitted in the form, just use that exhibit. Okay. I think my staff explained to you that in terms of submitting exhibits to the court in advance, if you would provide 2 copies of the exhibits in notebooks, so 1 copy in one set of notebooks and 1 copy in the other set of notebooks, and try not to make the notebooks bigger than about 1.5 inches each, at least on the copy you give to me, because it's just too unwieldy to use a 6-inch binder up here. Or if I need to take it home and read it overnight to do that. So try to keep it to about 1.5 inches per. And then for the actual exhibits that are going to be admitted, provide those first day of trial or whatever to the clerk in each exhibit in a manila folder with the exhibit number marked on the outside of the folder on the tab with the sticker attached inside the exhibit, so that she'll have a box of the proposed exhibits, the originals, and you can ask for exhibit X or whatever and she'll hand it to you to use. At least for the document exhibits and photograph exhibits. Physical object exhibits, work with the marshals on getting them in the courthouse. So for example, if it's something that's going to raise alarms at the security line, such as, I don't know, a knife, make sure you've got the aid of security in advance to get through that. The TCA can direct you to the marshal service and who to talk to there. We tend to use for dangerous items like guns and knives, a display box that the item would then be locked in to display to the jury. And so that can go to the jury without fear of an accident happening. I don't think there are any guns in this case, so I'm not as worried about that in terms of those being pointed at anyone by accident. But in terms of the knife, will probably be in a display case.
Are they indicating, do you think that means they got a knife? Or just the sheath that they're going to put in a display case?
If you're going to be using illustrative exhibits.
Did y'all catch that too?
Notice of that is reasonably far in advance as possible for them to have a chance to look at those.
Why bring it up if they don't have it? Why would he bring up, use these type of things if they don't have anything like that in this
Items
case?
for which chain of custody needs to be maintained until it's admitted. I'm going to leave that to the state to figure out where it's going to be stored and how it's going to be stored.
Interesting point Chloe brings up.
With a sister agency, or whether you're going to have the sheriff up there bring down a trailer that can be locked up and kept at the sheriff's here property or something like that. However you want to do that, I'll let you worry about that. For physical objects, also provide color photographs so that we can have those in the record. At the end of the trial, we will likely give back physical objects to law enforcement to maintain. Depending on what it is, we'll see, and depending on what the outcome of the case is. But it's nice to have those color copies available for the record. Triple check all of your exhibits, particularly documents, audio and video, to ensure that there's nothing on there that is not supposed to be on there. Give audio and video to counsel far enough in advance they have the opportunity to determine whether they have an objection to anything in there, and you have the opportunity to either make redactions in accordance with the objection or to get a ruling from me about those redactions. What I don't want is the jury to be sitting in the back room while you all are making redactions at the last minute during the middle of trial. All right, for closings, kind of the same idea. I'll ask in advance for a time estimate, and then if it's reasonable, agree to it, but then hold you to it. A little bit more liberal, obviously on closing than in opening. If you're going to display things in closing, kind of the same light rule goes, which is lights on or lights off, so you'll have to choose. You can move about the well, but don't get in the juror's personal space. The state, when it gives me a time, I will keep track of that, and then for rebuttal, it'll be whatever you didn't use. So when you're giving me estimates, include your rebuttal in that. If you would like time reminders from the court throughout it, for example, if you're planning to keep 20 minutes for rebuttal, you can ask for a heads up at 30 minutes, something like that, when you have 30 minutes left, so just let me know in advance. All right, questions either about closings or about exhibits?
Your Honor, as to the defense exhibits, it would be helpful if they could be separated or at least delineated between which is for the penalty phase and the guilt phase, as the court will see when it looks at our spreadsheet of our responses to the defense exhibits. Some of them, we could see we wouldn't object to them in penalty phase, but we would in guilt phase, and they aren't clearly delineated at this point. If that's something that we could have addressed sooner than not, that would be very helpful.
Any problem with that, Ms. Taylor?
No problem. We did go over that when we met last week, and I identified which ones were for a phase 2 if we get there. I don't have a problem stating so, but we did make them aware.
Okay, well, maybe if you can just put it in writing so that they have it, that'd be helpful. That way we don't have any misunderstanding between the two of you. Thank you. All right, once you get and revise your spreadsheets based upon what we've talked about today, I'll start about part of what I'm going to do with the time that we have between now and trial is start going through all those, looking at what your objections are, getting my preliminary thoughts together on that, and then we may have another hearing just to kind of go over some of that if it's stuff that I think I can rule on in advance for you, or if I have questions, et cetera, but I'll let you know.
Jay Logston is no longer on his defense. I don't know why. I don't think it's anything nefarious, but he was the only male, and so I think it is all now female.
From us, Your Honor, thank you.
As far as objections, Your Honor, the court has issued a number of decisions on motions and limine motions to dismiss. from the defendant's trial brief, the defendant indicates that he plans to raise those same objections again at trial. And it strikes the state that if that's going to happen, to preserve the record if for no other reason, that should be done outside the presence of the jury, as opposed to interrupting testimony and presentation of evidence on matters that have already been ruled on by the court, if that is acceptable to the court and counsel.
So there's not a need to object again if I've already ruled on the objection. If you're asking me to reconsider, yeah, I think that's something you need to take up outside the presence of the jury, if that makes sense.
That does make sense. And on situations that may arise where we might want the court to reconsider, we'll definitely take that up outside the presence of the jury. I do want to make sure that things such as the model house that was the subject of a lot of objection, that there's
That should be an
ongoing
objection there, calling
to
a
it.
model house
I
again.
don't mind anticipating that and bringing that up before trial starts.
The
and outside
dollhouse.
presence of
She,
the
well,
jury.
she said model house. So
And to
maybe
be
not.
fair, I only have what was.
I thought I heard
proffered,
dollhouse. I was
right?
like, wait a
So
minute. And she
I
said
had
model
a
house.
general proffer that the testimony will be that it, as I understand it, that it is consistent with the general layout, but not to scale, and that it would be helpful for the testimony. I don't have a problem with an objection based upon what that proffer is actually at the time. And so I think that's fine. I don't think that there's a need for an ongoing objection once that's done, but that helps.
Yes, sir. Thank you.
I like the fact that he's trying to limit
Jury
the
instructions I,
interruptions
provided
of the
to
presentation
you,
of evidence.
I think yesterday, maybe pre-proof instructions. Did you get those?
I did not receive those.
Have we not sent those out? All right, I'll send those out probably today or Monday. They're not particularly, I think, controversial. They're pretty stock. On the pre-proof, in a capital case, there's a instruction. Normally what we instruct the jury is don't concern yourself with punishment, the subject of punishment. In a capital case, we are supposed to instruct them under 700B of the capital instructions in the pre-proof phase that it is a capital case, which obviously they're going to know through jury selection. So there's that instruction in there. And what I've done is we're also supposed to instruct them with 700C, which is this is a capital case and you'll have to decide if you find the defendant guilty, what penalty to impose. But then 700C says, instruct them in a separate instruction, don't concern yourself with the subject of penalty or punishment in the guilt phase. I've combined those two things together. So take a look at that. I think it reads better than trying to do two separate, potentially contradictory instructions. I think that does it in a way that makes it more understandable. Other than that, they're very, very stock instructions. If there are other instructions that the parties want to be included in the pre-approved, for example, any stipulations that they want me to advise the jury of, let me know by submitting a request and copying my law clerk on that as well. I think you'll probably get before too long a set of post-proof instructions that are very loose in the sense that obviously I can't anticipate everything. It is based on what I sort of understand now. But it's helpful to have a discussion about that as early as possible so that we're all singing from the same hymnal in terms of what the likely instructions are going to be. And, for better or worse, as you know, the Supreme Court in last year in 2024 revised all their capital instructions. And so in light of that, I will be as much as possible sticking with what they have provided, given that it's clear they've obviously given it recent thought. And so I think that best insulates the case from perceived error by the court is by using instructions they've recently given us. My plan would be if there is a guilty verdict on the any of the counts of murder, would begin the penalty phase as soon thereafter as we can. Certainly probably the next day, unless it's, Friday morning when we get that, then we may not start till Monday or something, but given that the jury will certainly be sequestered during that process, the plan would be to go forward. I also will use as much time as I've told you throughout the day to get that accomplished as we can. If that happens and we are in a penalty phase, and there is a finding of aggravating circumstances, where then the court's discretion about which penalty to impose is pretty limited in terms of my discretion. In fact, i.e. none. It's either life without parole or death, right? In that case, I just want to get, before we get to that, defense's position on sentencing for the burglary charge, if they have concerns about sentencing at that time as well, given that it's probably not even a tail wag on the dog, let alone wagging the dog. So, but I'm not going to make you tell me that now, but I will ask you before the jury goes out what you want to do.
Getting real now, folks. Getting real. He's starting to sway now.
I'm going to hand you another piece of paper.
It didn't last
I'd
long.
like to get back from the defense.
He's back to being very stiff again.
Sometime in late June or early July, which is a declaration of last best offer. In other words, identifying whether the defendant received an offer and whether he has accepted, rejected, et cetera, just so that for purposes of post-conviction, we've documented that. Okay.
Oh, that's interesting. I can't wait to see what that thing is there. If they've given him a plea, if they've offered, rejected, they've offered a plea.
Court reporter know whether you're going to want routinely daily transcripts or not? You don't have to tell her now, but
Daily versus real time.
so there's two options. You can have none, both, or all, or either. One is I think we can set up real time where you get real time at your table for whatever the charge is from the court reporter for that. Also, there's the potential to get transcripts each day. I don't think those things are mutually exclusive. In other words, you could order both.
There's separate fees if I want both.
Correct.
Yeah, make that decision.
Yes, not now. You may make that as we get close. And just contact the TCA and she will talk with the court reporters that will be assigned to this to make sure you understand what their structure is, or fee structure.
Thank you.
And we obviously need to know, particularly about the real time in advance, so that we have the technology set up for it. And it may require you to bring some of your own technology in the form of a tablet or a laptop on which it's displayed, right? Because we don't supply the hardware, just the software and the actual reporting. Okay. My plan today, as we sit, is to get through the jury selection. I see where we're at with the intent that we not sequester to start.
Interesting.
As I explained this morning, the more people talk to the media and the more things that are in the media that are not admissible, whether true or not, the more difficult it makes things. And so I'm going to have to figure that out as we get close. For now, intent is not to do that, but we will have plans in place to revert to that if we have to at any point during the trial.
Did he watch the Dateline?
Do either of you want to make a record about sequestration at this point?
I would say the only record right now is that we understand what the court is saying during jury selection. If we still don't know if that could come up, the potential jurors should just be aware that it could come up prior.
It'll be part of the question that the questionnaire, as well as part of the hardship determination is there some reason they would be unable? I get that they wouldn't like to be, but would there be unable? Do they have a sick family member they care for or whatever, where they have to be home, right? So we'll talk to them about that. Anything from you, Counsel, Mr. Thompson, about that?
Not at this point. I understand the court might entertain some things.
Speak
in a
up, man.
closed environment later today, and we do have sensitive issues to raise at that point.
Okay. That's my list of things. Did I miss anything, Giovanna, that you can think of? All right. That's my list of stuff. And I know this has been a very sort of nuts and bolts kind of lawyer discussion today, but that's generally the nature of pretrials when there aren't contested motions to discuss. And so that's my list. I'm happy to answer any questions about my preferences or how I handle things that I haven't talked about, or address anything else that you want to talk about. I know we do need to go to a closed session at some point to talk about what will be asked of the jury specifically. I need to avoid that getting out to potential jurors. So we'll do that in a closed session. But anything else in the public session we need to talk about?
I believe so, Your Honor. Thank you.
Your Honor, thank you.
Okay. Let me just look at my notes real quick before I dismiss the public, and we probably take a lunch break and then come back and take that up. I do have a copy. I told you there's a new administrative order. I'll give you a copy of that just so you don't have to go dig for that. What's that? You've already given it to him? All right, perfect. Thank you.
Spare that we could have, Your Honor. That
Sure.
Oh, it's already at hand. Thank you.
Actually, I have copies of the preliminary instructions for you.
Oh, thank you, sir.
In the closed session this morning, I indicated to you I am going to be entering an order requiring retention of records by the state, and I'm going to write another one extending that to the defense as it relates to violations of the non-dissemination order. I'm going to give you a copy of what that order is going to look like that I will execute likely over the lunch hour. It does require some action on your part, counsel. And as I indicated, I would be open to a request for a appointment of a special prosecutor, and that special prosecutor to ask for a magistrate inquiry so they have the power of subpoena and the power to question witnesses under oath, as well as the power to grant immunity. So I will be looking for that from you. And that one just deals with the state. I will get you one that deals with your side. to preserve records. All right. All right. Anything else? All right. Thank you. Why don't we come back in about an hour? All right.
All right. They it appears that the remaining portion of this is going to be closed. So kind of just go over what we what they spoke about earlier. They're going on a lunch break. But a couple of things. Let me go back here. Let me see if there's anything new. I don't know why I look so like I'm not going very well. All righty. Okay, so just to kind of break down, I know a lot of people are asking what happened to the penalty, or not the penalty, the alternate suspects. Apparently, Ann Taylor didn't bring the evidence to back it up. So, judge asked her, we actually need to see the actual evidence versus just an allegation, and how it is that whatever she brought is admissible because he believes that much of what they have alongside with the allegation is, quote, objectionable. About its admissibility. So she didn't bring in the information. So what he did is he extended the time saying, all right, well, you brought a name, you brought an accusation, you brought a person. He mentioned Dylan and Bethany as victims. So I highly doubt that that's going to be a scenario where they're going to look at them as the alternate suspects. I don't know if he would call them victims to that extent in a public court hearing like this without doing so. And I think he may have done that strategically, knowing all eyes were on this case, knowing that he was going to be, that people are looking at these young ladies as potential suspects and wanted to put that out there that, no, that's not the case. These are victims and they're victims to the burglary charge. Now, a lot of people are like, burglary, was something stolen? Possibly. I don't know if anything was actually taken or not. However, the burglary aspect of it is different than just going in there and taking something. Some folks, think that a burglary charge is just a theft charge of somebody's house, car, or store, things of that nature. And that's part of it. But part of the statute for burglary is also to hurt, injure, sexual assault, things of that nature. Now, for instance, in Texas, and this is one of the easiest ways to explain this, we have what's called burglary 1, first-degree felony burglary, and then we also have what's called sexual assault, which would be the R, right? Now, in the state of Texas, now this was several years ago. I don't know if things have changed in the last 15, 17 years since I was in law enforcement, but when I was in law enforcement, the SA charge carried a second-degree felony. Now, if somebody broke into a house and then committed an SA on somebody, they would charge them with burglary 1 because it's a felony. Felony 1, it comes with a higher charge, it's higher prison term, et cetera, et cetera. And in that statute, it indicates that it's more than just the theft. It's also injure, harm, SA, et cetera, et cetera, et cetera. I know I've been asked to say that correctly. I'm sorry. I'm from the South. That's how we talk. Well, anywho, to me, I just feel like they don't have any evidence. So it's not going to be the Dylan and Bethany. And I like the fact that the judge said not only once, but twice that was going to be the case, that they were victims. And like I said, obviously they're not victims to the murder charge because their lives weren't taken. They'd be victims of the burglary charge. All righty. And let's see. I noticed that there's only like one burglary charge against Bryan Kohberger. I know that some folks think that maybe he went back that morning into the house. I don't think that he went into the house. I think he went back to the crime scene. I mean, there's a good possibility that he didn't realize he left the knife sheath behind until it became public knowledge that he left the knife sheath behind, or that it started to become a rumor in the area that the knife sheath was left behind. This guy may have been so focused in everything and just wrapping everything up together. He may not have even realized that he left it behind. And the other thing is too, during the trial, I got to thinking about, the lack of DNA in his car and the amount of time that it took for him to leave, which was, remember, Dylan calls Bethany at 4:19. So I know that the video is leaving at 4:20 and like 48 seconds. But there's about a minute and 48 seconds there, maybe a little bit longer than that, because when Dylan's calling Bethany and telling her what she saw, she'd already made other calls to other people in the house. And this person had already, the intruder that she saw had already left. So it's probably closer to 4:18, maybe even a little bit sooner than that, but 4:18 for sure. So you're looking at about maybe 2 minutes to 2.5 minute time frame where he's outside of the house and mitigating himself, right? Blood loss, blood, that's on him and things of that nature. And so to me, I started thinking, well, yes, it makes sense for him to disrobe and take everything off, but it also makes sense for him to maybe put on a suit. Maybe he put a hazmat suit or something of that nature, or a painter suit on the floor, and he jumped into it, sipped it up, and now he's contained himself until he can get somewhere out in the middle of nowhere to disrobe, change, clean up himself before he gets back on the road, which is why when you look at the time in which he left at 4:20, 4:48 is when his phone comes back onto the network. It's about 7 miles away, 10 miles away, somewhere around there. It's near Blaine, Idaho. It's not too far. You're looking at about a 10-minute drive, yet there's 18 minutes there. We don't know what he was doing out in the middle of nowhere. And I'm accounting this as far as this back road that I had found, not the typical way of driving to get to Blaine, Idaho through I-95. I'm talking about the back road to avoid the cameras that he would have had to have taken to have gotten there, and avoided those same cameras. And so it would have been about a 10-minute drive. So we're looking at about 18 minutes of unaccounted time where he was probably there then taking off all of his clothing and switching into another group of clothes and cleaning up as much as he possibly could. He's probably doing some other things to himself and celebrating his moment there before getting into his vehicle and taking back off onto the roadway. What else did they bring up? And so I talked a little bit earlier that, all right, who could this alternative suspect be? I think they're going to probably point at Jack DeCore and maybe somebody else close to their grouping. Jack is a guy who was with the victims that night. He was at the corner club. He was the person that they were calling and text messaging. Now, I know that the defense is going to try to say something to the effect like, oh, wait, Jack DeCore was with them and stuff. But and his motivation was because she was moving and leaving, and she's the one that broke up the relationship. However, she was the one trying to regain the relationship. The text messages and voicemails that were left to Jack DeCore that night were in reference to get back together, to try to make things work out. That's what she was telling to Adam. Remember, I told Adam everything that she told Adam was that her plans that she wanted to get back with Jack DeCore. And so that's what all that indication was. I've been able to confirm that as well. But those voicemails and text messages go against this supposed motivation that she left him and didn't want to get back together. This might be something that is reason why Judge Hippler's wondering if there's any admissibility to this. Well, anywho, Jack was there. He was at the corner club. He lived down the street, which kind of goes against also the other part of the evidence of the white Elantra. That white vehicle is pulling into an area that is a one-way in, one-way out situation, right? And so that vehicle pulls into that area and then does not leave until after the times that the murders have occurred. And there's audio and sounds and a download of victims' phones and surviving victims' phone numbers, phones that were downloaded to determine and pinpoint the exact time that this crime had occurred. And during that time that this crime occurred, that white vehicle that had passed by and left, I mean, each time that it went into that intersection was only in that area for a few minutes, maybe 2-3 minutes tops, and then it was out of there. It would pull in, go around the apartment complex, pull up behind the victim's residence, slowly creep around it, and then pull away. The only time that it stayed in that area for a longer period of time than that was during the specific time that the murders are occurring. And then immediately after the murders have occurred, this vehicle is being seen driven at a high rate of speed out of the area. So you can pinpoint when this, this situation had occurred, in my opinion. And you're looking at the white Elantra being used. There isn't a guy walking from the 1119 King Road residence, which is where Jack DeCore lived at the time. And Steve also mentioned that they have his phone, and it moves a little bit during the time, as if he had his phone under his pillow and he was moving in the bed. So he's accounted for. There's cameras that face that direction. There isn't somebody that's leaving. There's a white vehicle that's driving around in the area. It can even be videotaped on Taylor Avenue behind it. There are documents that indicate that, its movements, and that they can see it in the, behind the house. So if Jack jumped out and got into a vehicle or any of those things, that would have been dictated on that footage there of that vehicle coming behind it. So their alternative suspect thing, I don't think is going to end up going anywhere, but they extended it because they gave a name. That date is going to be for May 23rd. And then the state is going to have until June 6th to come up with a response. And there's going to be a hearing on June 18th at 12:30 local time to Boise, referencing the alternative perpetrators. They went into some jury questions, voir dire questions with the jury. They talked about how during the questioning, they're not going to broadcast that out to the public. They're going to have it broadcasted to a separate room within the courtroom where people can watch, but it's not going to be put out to the public. I referenced that I might be able to try to get out there for that. They talked about some trial dates. They're going to be going Monday through Friday, 8:45 a.m. to 3:30 p.m. local to Boise time. There will be no trial dates between October 2nd and 3rd because the Judge Hippler has a pre-thing already planned. They talked about potential holidays that they do not intend on having trial because of the holiday, but if there is a sequester of jurors, then they probably are going to take advantage of it and just do trial on those days. But throughout the entire process, and especially at the end, it just does seem like Judge Hippler does not want to sequester the jury until the very end, until there's jury deliberations, until he absolutely has to. I don't foresee that being feasible, to be 110% honest with you guys, especially with today's group of people that are growing interest in true crime that'll show up. And then you account that with some folks that just kind of take things a little too far. We've seen numerous trials where we've had creators chasing jurors and trying to get video of them leaving or entering courtrooms, or trying to identify who jurors are in other court cases as well. And so this case here is probably bigger than those cases. Now, I don't see Bryan Kohberger's pro-burger movement as big as maybe, for instance, like Free Karen Reed, and I strongly believe that it's bigger than the Richard Allen case, and those that believe that Free Ricky, I think is what they call themselves, that movement is. So it's in between there. In my opinion, I think it's in between there. It's between the Ricky Allen and the Free Karen Reed. And in both of those scenarios, people from outside made enough noise that they got involved and they took videos or pictures of jurors. I wouldn't be surprised of a movement like the pro-burger movement that is in between the sizes of those two movements wouldn't do the same. And so I don't see this feasible, to be honest with you. I think it's going to come down to them being sequestered when it's all said and done. I think when they do the jury questions and the amount of people that show up for that, and I think that's going to be a real indication of whether or not it's going to be feasible to do. But me personally, I don't think so. I don't think so. KR jury isn't sequestered either. Oh, that's interesting. I didn't know that. All right, let's continue this. But, I do think that it does play a role if there is a sequestered jury or not. The pro-burger movement, those guys, I just can't see how they're not going to be posted up trying to figure out who these people are. And if they do, I can totally see them that they're going to go out to these people's houses. They're going to be going out to these people's, like, everything. It's just it could be a total nightmare. I hope it doesn't happen, but it those that believe that Bryan Kohberger committed this crime, which is most, let's be honest, it's most. I call the pro-burgers the squeaky wheel. A squeaky wheel is the loudest. It makes the most noise. It's not right. It's usually wrong. And it's not the majority. It's just the loudest of the group. You know what I'm saying? You don't hear the other ones because they move right. They work properly. The squeaky wheel doesn't. And so, I can see the squeaky wheel making a lot of noise in that scenario. All righty. So let's see. What else did they bring up? They talked about a knife, guys. They talked about a knife. And I thought that was interesting, but I don't know if they found the knife. I don't think they did. To my knowledge, guys, I don't know. But to my knowledge, the last I heard, they didn't. So what I think that this could be, as far as displaying a knife, it could be a demonstrous exhibit, a K-bar knife similar to the one that they use to show the jury the sheer size of the knife and its capabilities when it comes to the injuries to the victims, and saying, all right, these victims succumbed to stab wounds and probably maybe other blunt force object injuries, like the bottom of the knife being used in a certain manner. They're going to be able to see that. I don't know, and I'll ask Chloe if she's still in here. Is that something that they can take out of the case to carry? Because I think the weight of the item is also important. If one of the things that Steve said was that the stab wounds, if the stab wounds didn't take Kaylee's life, the wounds to her face and head would have. I think the weight of the item is probably important. And so I don't know if that's something that could be passed around. I would think so. I would hope so that they can get a full understanding of that aspect. But I don't think they also mentioned gun, and I know that in Pennsylvania there was a knife and there was a gun confiscated and turned in. And so I don't know if they're going to use that in some form or fashion. They could, based on everything that I understand and know about this case, it doesn't appear that there was a gun used. So I don't know, but I don't think so. I'll leave it at that. But yeah, to me, and I know people were pointing out that Hippler mentioned twice that knife, and it's a possibility, but I think it's more so a demonstrous example than it is something to do with the actual knife in this crime. I strongly suspect that guy. It's very uncommon to sequester the entire trial these days. Maybe so. I'm not like you guys have more experience than me. I've only seen a handful of trials. I would have thought that, just given the high profile, of the case and the sheer amount of information that's out there, that it would probably be a smart decision to do so. But maybe you guys are right on that aspect. No evidence of gun at the scene, though. Yeah, that's what I'm saying too. I don't think I've never seen anything about a gun at the scene. But that doesn't mean that I don't, that evidence could not be out there. I mean, remember in Richard Allen case, they brought out, the gun that was a round that was extracted out of his gun. So who knows what they may have that we don't know. Let's see. Just a whole big deal. Anytime anything dangerous comes into the courtroom, knives, guns, drugs, etc. Interesting. I know at least one of the blonde women behind BK is a Kohberger. Yeah. I don't know. I know that the other side is victim family members. I know that Steve Goncalves, I think they're there. I asked him, I told him yesterday, have safe travels. He said, thank you. I didn't ask him if he was going to be there, but I think he was there. But when he's been there in the past, he's told me that they're just off camera, right behind the prosecution. All righty. One of the other things that I that I saw about this is that, Judge Hippler's really laying down the hammer. He was basically saying, like, look, we're not going to have any interruptions. If you have any idea of any objections that are going to come up or any of these things that you think might happen, I want to know beforehand. I don't like surprises. I've seen other trials, mainly only one other one. There's only really one other one that I've been watching, so you guys probably know which one it is. But there's constant sidebars over and over again, and I think it's a defensive tactic to do so, especially when the prosecution is explaining some evidence. They're getting into the explanation of the evidence, and then boom, sidebar, this, that, boom, 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 just to interrupt and confuse the jury. It's a defensive tactic, and I like the fact that this judge is like, no, you're not going to do that on either side. Either side is not going to do that. If you see or foresee a potential objection coming up or an impeachment or any of these things, he wants to know about it before. He does not want to make. I've seen other judges where it seems like, and this is just my opinion, it appears that under pressure, they may make decisions that benefit more towards the defense. I think with this guy, if pressured, whether it be on either side, it sounds like he's not going to stand with whatever side you come up with. So if the state is the one that's going to do the pressuring of a decision under pressure, I don't think he's going to side with the state. And the same thing with the defense. I don't think he would side with the defense unless it's something that's obviously apparent and must be done. But if it's something that needs further thinking, so to speak, or further evaluation, I think he's not going to side with the pressure of the question aspect of it. I hope that makes sense. And I hope you guys understand what I'm trying to say with that. But he laid down the ground rules. He doesn't want any interruptions with the presentation of evidence on either side, prosecution or defense. And I think that's the way it should be. You know, I understand that there's a tactic out there and it's effective in some degree when it comes to trying to pause and break and confuse the jury, make them perhaps, if you put a break between, you know, point 3 and 4, you're hoping that maybe they're not making that connection. And then that starts to maybe make other questions when they're trying to make other questions or connections to the evidence because you're putting so many pauses and breaks in between. So it's an effective tactic. And I think the judge understands it and he knows that. He's been experienced in this for some time. He mentioned that. You know, he sounded a little bit arrogant. I'll be honest when he said, hey, most of the time, I know what you're going to object to. I'm going to object to you right away, or I'm going to side with you, or I'm going to, you know, tell you to go on right away. But if you feel that I've cut you off at the knees and that I need to hear your objection, I'll let you talk. But for the most part, I understand what you're going to be objecting to. I know what you're leading to. And so I like it. I like that he's confident in his ruling and he's confident in his powers. You know, that was one of the things that came into question from the defense and Ann Taylor and I think it was the Massoff, I think, who's the one that said to, or maybe it was Ann Taylor who told Judge that maybe he wasn't confident or 100% sure about the powers that in which he had. You don't get that sense here with Judge Hippler, and I would love to see them try to make that kind of statement that they made with Judge with Judge Hippler and see how that goes out. You know, the next thing that I wanted to talk about is the fact that if he's found guilty and the jury comes in and says, hey, he's guilty, the very next day they are deciding his fate. I saw Bryan Kohberger move around a little bit. He talked about death and he talked about life without parole being the only two options here. You know, if found guilty. And, you know, he started moving around. You know, that was a moment where I said, it's starting to get real for you now, buddy. And, you know, I think at that point, you look at that side, that's when you realize that, yeah, it's real. You know, they're not going to wait. They're going to make that order fairly quickly. That makes me wonder if this, and I'm fairly positive I know the answer to this. I wonder if Judge has already made his decision. If this guy's found guilty, he's going to be given death. I mean, granted, he said if there's any aggravating factors, he has to make that decision, blah, blah, blah. But, you know, I wonder if his mind is already meant like, all right, if there's aggravating factors and this guy's found guilty, it's death. Right. You know, I wonder when you make that decision, because that decision, that's a tough decision to make. You know, do you go through all the evidence and listen to it? Obviously you're going to, and you're going to do that, but do you have to prepare yourself for taking somebody's life like that? And it's a decision that he has to make, that he took an oath, and that it's a hard decision to make. I mean, it's the same thing that law enforcement officers, you know, have to make when they decide that they're going to become officers and they're going to go out into a dangerous situation. They understand that every call could be a very serious call, and that they may have to discharge their weapon if need be. And in those decisions have to make those split second decisions to do so, because that could cost the life of themselves or the lives of others in many cases. And so, you know, when do you start making that process? You know, for me, I started thinking about that way before I was a police officer. You know, before I joined the military, actually, is when I started thinking about that. If I was put in a situation where I had to take somebody else's life, would I be able to do that? You know, that's not something that I wanted to think about in the moment. You get what I'm saying? And so, as a, you know, for a judge, I wonder if they have to go through the same process and mindset and preparation of doing so. Because if you find yourself a situation where somebody is frozen in time, where they don't move or they don't make a decision, it's probably because they hadn't thought about that decision beforehand and put themselves in those positions. And so you really got to go through that process. And I'm wondering if he's already said, okay, if we, you know, it's going to be black and white. That way he doesn't have any emotion involved in it. That's way it's not like for instance, another example, like when an officer pulls somebody over, many times I would pull the person over and I would say on the camera before I walked up and approached to the person, whether or not I was going to give them a citation or a warning. And I did that because I didn't want somebody to come back and say that the reason they got a citation was because of the contact that we had. And so that if I got up to somebody and that they're upset or arguing or yelling or being disrespectful and rude to me, well, I mean, I said already I was giving this person a warning. If I go back and change that, then that's showing bias. That's showing that I am affected by emotions based on what they're saying. And so I practiced that quite a bit every time I did that. And so you do that to take yourself out of the situation, out of that situation of your emotion, and just doing, all right, this guy was speeding and he surpassed the limit that I give a citation to for everybody. So that way I can't be perceived as being unfair at any point. Boom. So I wouldn't be surprised if he's already made that choice or that decision. You guys let me know. All right, I'm going to go back. I started a couple of questions, not too many, throughout the conversation. If you want me to answer yours, let's star them. Let's see. Becky comes in. Sorry, I wonder if Bryan will take the stand. It'll be interesting to see his actions. I don't think he will, but he may have to. You know, it might be a situation where he has no choice. I just want to just check. I know they said an hour. It's not been that long. But yeah, offline. They're going to be done for the day. All righty. What do you think they will do with the model house after the trial? They'll probably destroy it. You know, I wouldn't be surprised if it goes into some incinerator. I don't know, maybe some weird person will offer them a lot of money to add it to their murderabilia, I think is what I call it. I heard it being called. Some folks buying certain things called murderabilia. I don't know, maybe it'll be in some weird attic or something like that. But I would think most likely it'll probably get destroyed. Let's see. I thought maybe BK took the knife to Pennsylvania since they found it there. So he did have a knife with him in Pennsylvania, but it didn't specify what kind of knife. Okay, great thing Tomlin brought this back. Sounds like plea offer may be procedural in order to avoid applicable errors. And so I don't know. I don't know if a plea deal has to be given to avoid that. I do know that. I don't know. This is a good question for Chloe, to be honest with you. I don't know the answer to this as far as it having to be a situation, but obviously we're not going to find out if Bryan Kohberger offered a plea or offered to take a plea, right? Because what if, you know, Bryan Kohberger's defense team says, hey, if you take the death penalty, we'll plead out. And the state said no. Well, if that got out, that's pretty crazy. I mean, that's pretty prejudicial against him before the trial, before any hearing, before any of those things. And it's also an indication that he's willing to admit guilt here, right? Of some sort. And so we're not going to find out one way or the other. That's unfortunate. I'll be really interested to know this at the end when it does become revealed, if he ever offered to take a plea or if there was ever a plea offered to him and he rejected. That'll be very interesting to tell. It would be more interesting if either side either didn't offer to take a plea or gave one out. That would be interesting too. Couldn't flip in here, Thompson. So they are addressing perps at different day, having a sealed hearing to discuss sensitive topics after lunch. Yep, that's basically it. Yes. All right, let me scroll up a little bit. They could do a model K-bar just to show how heavy it is. I think they rather use the real thing. And there's evidence that he had one at one point, right? Because he purchased one along with the K-bar knife sharpener. And so it's not just the fact that there was a K-bar knife sheath left behind. It's also that there's a missing K-bar knife that was purchased along with the sheath that is also missing. And so I think you can probably use the K-bar in that instance to do so. Let's see. Yeah, that's the reason why Hippler was upset at AT taking 8 million years. There's no question that he is in control of the courtroom. He will not tolerate any shenanigans. I like it. I like it a lot, guys. You know, he was very stern and he doesn't like surprises. He wasn't talking just to the defense. I mean, I know he's kind of looking over in that direction, you know, kind of expecting more of if there's an ambush, if there's any of those type of things, it's probably going to come from a defense because it is a defense tactic. I mean, it is what it is, and you would expect to see it. I've seen it in a few. I've only seen a handful of trials and hearings, but it would be a good tactic to do. And so, you know, he's anticipating those things happening. Bryan looks huge when he stands. Well, that's the other thing too, right? They're trying to make him look small. They have him sitting there, and they have everybody else's chair all the way up and his all the way down. So yeah, they're trying to make him look small. Like, oh, he couldn't have committed this crime. They had to put on the record before trial whether the defendant was offered a plea or a deal if he rejected them. Is that whether the defendant was offered a plea deal and or if he rejected? Do they have to put on the record if he asked for a plea, Chloe? And does that become public record before the trial? Because I don't know the answer to that. I really don't. I don't think it would be, but I'm curious. Offered any deals are not required. Yeah, I know they're not required, and there could be a situation where they're not. But I'm wondering if there is a situation where they have to disclose whether he offered to take a plea. So we have to wait until June for the alternate suspect, another AT tactic. Yeah. That's the first thing that I thought. I was like, man, they're really just they purposefully let's just say they have some evidence that they can bring in. Now, some evidence doesn't mean that this person committed a crime or whatever the case may be. But let's just say they're like, hey, we think it's this guy. You know, his phone was just at home, and he also drives a white Elantra. But nothing else, right? There's none of his DNA at the house. There's, his phone was on, but it was at the house and it just didn't move because he put it on the table. And so his alibi was he was asleep. And there's a camera, facing that way. And you can tell that he didn't leave unless he went through one of these secret tunnels that the Kohbergers say that there are throughout the city of Moscow. You can get to everybody's house through these secret tunnels. Let's just say they have something like that. Like, to me, I mean, that's not enough either way, but I don't know. I mean, I think you would need more than that, than just the white Elantra, and he wasn't moving that night, because they have more than that for Bryan Kohberger. Because if all they had was he drove an Elantra, and even if all they had was he drove an Elantra and his phone was off, that one would be hard. That one would be hard. I mean, you would know, obviously, especially going back, looking at all of his history and stuff. If he didn't leave that sheath behind, that would be hard. That we don't have to discuss that as a realistic thing. Let's see. No, only if he was offered a plea and rejected it. So we won't ever know if he wanted to take one. All right. Well, thank you, Chloe. I appreciate your response. BK dug his own tunnel with a trench shovel. He had it. Secret rabbit hole. All righty, guys. Well, they're not coming back. That's going to do it for me today. I'm going to be back on tomorrow night with Dr. Vona. We're going to talk about some of Bryan Kohberger's searches that came out of the Dateline. We're going to look at some other searches that he may have made while he was in Washington before the murders. That might spark your interest. So like, comment, subscribe, ring that notification bell. You guys know what to do. We'll be seeing you guys tomorrow night. Peace out.